Well, pertaining to Kohima Bench, item number 1.
I don't know how item number 1. 94 of 22. 94 of 24. 94 of 22. আৰু আছে 94 of 22 দে for reasons mentioned in the judgment, this writ petition is allowed, and the petitioner, the NHIDCL, is directed to pay the compensation of rupees 1,16,47,063 to the petitioner within 3 months from the date of this order. After making the payment, the NHIDCL may invoke the indemnity clause of the EPC contract between itself and the EPC contractor to get reimbursed by the EPC contract in respect of compensation paid by it to the petitioner.
I'm deeply obliged, my lord.
Item 2.
Item 2, I'm deferring this judgment. It will be pronounced on 30 January.
Item 3.
This writ petition is allowed. The state respondents are directed to regularize the services of the petitioner in terms of the office memorandum dated 17/3/2015 within 3 months from the date of this judgment.
Item 4.
My lord, I am for the respondent. My senior Dindeswar Talazar Bhagat is suffering from spinal cord injury.
No, this is not pertaining to, you wait for your turn. This is item 4 of Kohima bench. This is not of the, you wait for your turn. Item 4, for reasons mentioned in the judgment, this writ petition is dismissed.
Obliged, Raj.
Item 5.
For reasons mentioned in the judgment, this writ petition is dismissed.
Item 6.
This writ petition is disposed of with a direction to the government to consider the prayer for regularization of petitioner number 2, 3, and 4 expeditiously. And if after such consideration, it is required to reserve the post of any number of posts for regularization of those candidates, same shall be done. And certain other directions are given. This writ petition is accordingly disposed of.
Much obliged, Lordship.
This delivery of order, item number 1.
For reasons mentioned in the order, this court is of considered opinion that the petitioner is entitled to get bail due to violation of mandatory provision of section 36 of the BNSS. Accordingly, he is allowed to go on bail of rupees 1 lakh with 2 sureties of like amount subject to certain conditions.
Obliged.
May I please your lordship? Lordship, I beg to mention item number 15, lordship. Lordship, matter will be, may be taken up another date, lordship.
Why? There has to be some reasons.
Lordship, senior engaged counsel, Mr. L.K. Bora, yesterday fell down from the
Okay,
staircase.
okay.
Got
Okay.
injured. in
You
his
have to
right leg.
mention the reason also while praying.
Lordship.
What is your name?
15.
What is your name?
D.K. Bora, lordship.
Heard Mr. DK. You have informed the other side.
Yes, I have consent from the other side, lordship.
Heard Mr. DK Bora, learned counsel for the appellant who prays for an adjournment on the ground of personal difficulty of the conducting counsel for the appellant. He submits that he has informed learned counsel for the respondent regarding his prayer for adjournment, who has no objection to the same, hence the prayer is allowed. Let this matter be listed
Any date, lordship.
on 5th of March.
Lordship. Highly obliged.
May it please, Your Honor. My lord, item 8 is a contempt matter, my lord. We are withdrawing it. The orders have been complied, accounts have been released.
Okay.
Lordship, I am the contender number 2. Lordship, I have no objection for withdrawal, Lordship, but observation may be made directing the trial court to dispose of the matter. It is fixed on 28th of this month.
No such observation is required. He is withdrawing the contempt. We are just allowing.
No, that is correct, Lordship.
My
But
lord-
similar order was passed by your Lordship in the petition on 12th of December 25, directing the trial court to dispose of the matter.
No, but in a contempt petition,
No, I understood,
Huh.
Lordship.
okay,
But
heard.
that will not cause any prejudice to my learned friend or.
Heard Mr. B. D. Decker, learned counsel for the petitioner. Also heard Mr. S. P. Roy, learned counsel for
Contempt 2.
respondent number 2.
I am for 1 and 3.
Also, Mr. A. K. Gogoi appearing for respondent number 1 and 3. Learned counsel for the petitioner submits that as the order of which contempt was alleged in this case has been complied with by the contemners, the petitioner does not intend to pursue this matter and prays for allowing him to withdraw this matter. The prayer is allowed. This contempt case is accordingly dismissed on withdrawal.
Obliged.
The IA is accordingly also dismissed. Connected IA is also dismissed.
Obliged.
May I please Lordship? With the consent of the opposite counsel, I beg to mention item number 20, today's list.
2-0.
Lordship, kindly adjourn the matter for the day. Due to some personal difficulties, my senior engaged counsel could not conduct.
What is your name?
E. Devi
You are for the
for responding.
respondent. Heard Miss P. E. Devi, learned counsel for the respondent, who prays for an adjournment on the ground of personal difficulty of the conducting counsel for the respondent. She submits that she has informed learned counsel for the appellant regarding her prayer for adjournment, who has no objection to such prayer. The prayer is accordingly allowed. Let this matter be listed on 24th February.
Bail hearing BA, item 2 and 3.
My lord, this matter, my lord, that is a 2-3, my lord, it is related to one, my lord, Jorhat case, my lord. That is a, my lord, one boy was, my lord, killed in the, my lord, that is a Bihu function, my lord. That matter earlier, my lord, Harded land, only, my lord, that is the, their part, my lord, in the TIP, my lord, their name was not there, my lord. Another one bail prayer was related to another one accused, my lord, Mon Borwa, that was rejected, my lord. So my lord was pleased to, my lord, call for a case diary to find out whether their link is there or not. Because there is one electronic evidence, my lord, that is, my lord, they have collected one CCTV footage also. My lord, that is, I have gone through the, my lord, that is the, my lord, the office record where it is stated that on 17/12, my lord, that is CD along with the, my lord, TCR was, my lord, received. So my lord, matter maybe kindly be fixed to, my lord. In the meanwhile, I can go through, my lord,
Today,
that part. If my none of the senior colleague has no
Lordship,
objection on
already
that part.
9 months passed, no trial is progress, no identified by the TIP.
let
The
him go
bill
through the
Well,
CCTV. We'll take it up.
At,
Not two, we have fixed matters.
okay, but then before that, my lord, or my lord, in the meanwhile, I will go through that.
Or at two, we will take bail application first. Thereafter, we'll take
Yes,
other
my lord.
fixed matters.
Because my lord, only that part, my lord, I have to look.
Yeah, that whether is there any evidence
Yes,
against them?
Yes, my lord.
If there is no
only that
evidence,
part.
they will get bail.
Yes,
If
ma'am.
there is evidence,
Yes,
their
ma'am.
bail will be
Yes,
rejected.
ma'am. Already, my
Oh.
lord had on earlier occasions heard
Okay,
on that part.
Then we'll take it up at
Two,
two.
my lord. Both the, my lord, arising out of the same, my lord,
Okay.
FIR, my lord. And my lord, along with that, another bail matter
Item
is also there, my lord. There is item number 22, my lord. In the, my lord, that is in the, my lord, supply list, my lord. So can it be taken together, my lord?
Okay,
Ito আপোনালোকৰ to. All bail
not
matter,
connected with this.
no, not connected with.
We'll take up bail matters at two.
At two, my deeply obliged.
Item 21 from supplementary.
The regular hospital manner under section 96 manner is a judgment and decree dated 30/5/2025 passed by the Learned Senior Division Hailakandi, thereby decreed the suit in favor of the respondent plaintiff during declaring the right and interest over the suit length. Suit schedule 1 land in favor and cancel one deed number so and so, further direct to evict the appellant defendant. Admitted parliament.
Heard Mr. A. Chaudhary, learned counsel for the appellant. This appeal under section 96 of the Code of Civil Procedure 1908 has been filed by the appellants impugning the judgment and decree dated 30/5/2025 passed in title suit number 3/2021 by the Court of Learned Civil Justice Senior Division Hailakandi, whereby the suit of the respondent was decreed and the present appellants were directed to be evicted from the suit land. Stop. The appeal is admitted. Issue notice to the respondents. The appellants shall take steps for issuance of notice to the respondents by speed post as well as by usual mode within 7 days from the date of this order, returnable on 27th February. Let the records of the trial court be called for from the trial court, the registry to take steps for requisitioning the trial court records, list accordingly.
I also violent because execution process is started now. That is the execution case number 20/2025.
What
Yes.
stage execution is pending?
This has been issued by law, we appear.
Okay.
Initial process initiated.
Councilor Nameke Takim. This application under Order 41 Rule 5 of the Code of Civil Procedure has been filed by the applicants in connection with RFA number 3/2026, praying for stay of execution of the impugned judgment. Stay of execution of the impugned of the judgment and decree dated 30/5/2025, passed in title suit number 3/2021 by the Court of Learned Civil Justice Senior Division, Hailakandi. The aforesaid judgment and decree has been impugned by the present applicant in the connected first appeal. Stop. Issue notice to the respondents. The applicants shall take steps for issuance of notice to the respondents within 3 days from the date of this order, returnable on 27 February. In the meanwhile, as the connected appeal has been admitted and as what is the execution case number?
Page 6, my lord, execution case number, title execution 20/2025.
As the executing court in execution case number 20/2025 has already issued process. Hence, since the next returnable date, the execution of the impugned judgment and decree shall remain stayed. List accordingly.
Obliged.
Yes, now you may submit.
I'm the respondent, docket for the respondent number, Kubita Sharma. And my senior is suffering from spinal cord injury. And he surgery was done in Chennai.
You are praying for adjournment. You
Lord,
come
however-
this side.
The matter is ready for hearing, my lord. PCR has been called for, it has been received, my lord.
Okay, we'll fix it for hearing.
2nd week of March. my
Heard Mr. S. M. Barua, learned counsel for the appellant. Also, heard, what is your name?
Kamal Krishna Taluk.
K.K. Talukdar, learned counsel appearing on behalf of Mr. D. Talukdar, learned counsel for the respondent, who prays for an adjournment on the ground that the conducting counsel for the respondent is indisposed. Considering the submissions made by learned counsel for the respondent, the learned counsel for the appellant does not raise any objection, hence the prayer is allowed. Since the trial court record has been received and since this case is ready for hearing, let this matter be listed for hearing.
March.
Let this case be listed for hearing on 10th of March.
May I please, your lordship? As per office note dated 17/1/26, lordship, notice delivered to respondent number 1 to 5, lordship. And I will, the lordship, take first step upon respondent number 6 and 7, lordship.
What is your name?
P. Sharma.
Heard Mr. P. Sharma, learned counsel for the petitioner. On perusal of the office note dated 17/1/2026, it appears that as per the postal track consignment report of notices issued to respondent number 1 to 5 by speed post, the said notices are shown to be delivered to the addressee. Hence, the notice issued to respondent number 1 to 5 are held to be duly served. Stop. It also appears that no, stop. Learned counsel for the petitioner further submits that he may be allowed to take fresh steps for issuance of notice on respondent number 6 and 7, prayer is allowed. The petitioner shall take steps for issuance of notice on respondent number 6 and 7 by speed post as well as by usual mode within 7 days from the date of this order, returnable on 25th of February, 24th February.
Item 6 and 7.
Maximum limit process, base process, base. Yes.
May I please, your lordship? Lordship,
Item
may kindly
number, Kiman?
6 and 7. Lordship, may kindly pass over the matter for the day, lordship.
Why?
Lordship, there is some difficulty, lordship.
What difficulty? It cannot be disclosed to the court.
Lordship, in this matter, I am seeking adjournment, lordship. There is another hearing matter, lordship, we will do that.
Oh, what is your name?
F. Ahmed.
Heard Miss F. Ahmed, learned counsel for the applicant. Move praise for an adjournment on the ground of personal difficulty of the conducting counsel. Considering the submissions, the prayer is allowed. Let this matter be listed in the, no fixed date, in the second week of February on a date to be fixed by registry.
Lordship. Lordship, actually, my senior, he is on legs in another court, lordship. There is another hearing matter that we will do, lordship. I'm obliged.
Hearing item number 9.
Please, your lordship. Lordship, my student is busy for another court, lordship. Matter may kindly for time being, lordship. Just take coming.
We'll wait for him. Let him come.
That is usual course, always they are doing this.
This is their usual pattern.
That is a usual pattern, that is main problem is there. Now we say that. She is coming, lordship. Now that she is in. Last date also that similar. pattern.
No, we'll take it up.
Once a criminal matter starts, once a civil matter starts, again, let us watch for the time. He says for time being,
Okay.
or if your lordship allow me, will she come with it short time? Short time. If your
No,
lordship-
let him come. Let
if
him
your
come.
lordship allow me, I can just start the facts for the facts.
And if he does not turn up thereafter, everything will. So let us wait for him.
10.
Please, your lordship. Lordship, can we take up this matter next week?
Heard Miss M. Chaudhary, learned counsel for the appellant. Also heard Miss P.
What happened?
Bodhakur, appearing for respondent number,
Company, respondent number 7.
respondent number 7, insurance company. Learned counsel for the appellant, prays for an adjournment on the ground of personal difficulties. The prayer is not opposed to by learned counsel for the respondent, hence same is allowed. Let this matter be listed. February first week video. 5th of February,
Honestly, you have some difficulty. Can it be on some other day? Excepting 4th and 5th.
3rd February.
Obliged.
Obliged, lordship.
Item 11.
Yeah, please, your lordship. Your lordship, kindly the matter may be passed over for the day.
Adjournment. Heard Miss B. Hajurika, learned counsel for the appellant. Also heard Mr.
D. Kolita, lordship.
D. Kolita, learned counsel for the respondent. Learned counsel for the appellant has prayed for an adjournment, which the counsel for respondent does not have any objection, hence the prayer is allowed.
Date may be fixed, lordship.
Let this matter first week of March, first week of February, first or second week. 5th of February.
Lordship. Obliged.
Obliged.
12.
Lordship, after some time, lordship,
Okay. After some time.
after some.
13.
May I please, your lordship? Actually, my senior is in late and yeah. After some time, lordship, at 2, lordship.
No, not at 2, after some time.
Obliged, lordship.
13 is it?
13 after something.
After Sunday.
Item 16.
My lord, I am for the respondents. My appellant counsel requested me that he will appear at 2. He has some other problem. So I have already prepared my gist of arguments.
You have already argued this matter,
Yes,
both of you.
already. Your lordship has directed to submit the gist of arguments.
Okay, you submitted,
Yeah, I am submitting.
or should we wait till 2?
Yes, at 2 I'll be waited.
Okay. You will only submit the gist of argument.
Yes, only submit the gist of argument.
Okay, okay.
Judgment is available before your lordship, I know. If it is required, I produce it.
Okay. We'll take it up at 2.
Yes, my lord. Then file to the.
একটু রাখি লব record.
Item 17 and 18.
Your Lordship, matter is possible for the time being.
Why?
Conducting counsel had to leave the court due to some personal difficulties, Your Lordship.
We'll adjourn it today.
Then Your Lordship, date may be fixed
You are for?
for the appellant, on behalf of Mr. S.P. Roy,
Heard Miss
P. Day.
P. Day appearing on behalf of Mr. S.P. Roy, learned counsel for the appellant, who prays for an adjournment due to personal difficulty of the conducting counsel for the appellant. The prayer is allowed. Let this matter be listed. 2nd week of February,
A date is fixed.
10th of February.
Your Lordship, but there's an interim order.
The interim order shall continue till next day.
19. Item 19.
None has appeared for the
Lordship, in this case, my senior, Mr. Edhar, will be appearing. He has some personal difficulty today, Lordship. 1st week of February, he have requested if a date can be given.
Mr. F. Faridi, learned counsel for the appellant, prays for an adjournment on the ground of personal difficulty of the conducting counsel for the appellant. None has appeared for the respondent side. Considering the submissions made by learned counsel for the appellant, the prayer is allowed. Let this matter be listed on 5th of February.
Much obliged.
Item 24 from supplementary.
I'm for respondent number 1. Claiming.
Appellant,
Appellants.
what is to be done?
Fix the date in the month of February, Your Lordship.
Appellant has come.
Lordship, the matter may kindly pass over for the day, Lordship, because my senior has some difficulties.
Fix the.
Okay, heard Mr. S.P. Sharma, learned counsel for the appellant. Also heard Mr. A. Hussain, learned counsel for respondent number 1. Learned counsel for the appellant has prayed for an adjournment on the ground of personal difficulty of the conducting counsel for the appellant. The prayer is allowed. Let this matter be listed on 5th of February.
Obliged. No, sir.
Mr. Sharma. No, not, there are other Sharma. Whether appellant has come,
Till now, they did not come, my lord. That is why I said, actually, they do not have merit in the case. The sister is claiming a property on the basis of a gift deed from mother.
Your item number is
Where is, my item number is 9.
9th of the auction.
Because there is no merit, so they are always avoiding the court. This case, see what happened, my lord? 1969, my father had given on will his entire property to me. Thereafter, I have filed a probate case. And my mother had also adduced evidence in my favor, in favor of the will. Ultimately, probate was granted. In the meantime, what happened? One of my sisters, whom I have allowed to reside in our house, she had somehow manipulated my mother, and entire property she had taken on gift from my mother. Actually, mother has no property because already father has, it was property, absolute property of father. Father had already given me probate by way of will. And thereafter, somehow she obtained the, she have obtained
What is the,
mutation in the name of mother,
what is the, how, it is a land,
the land,
how much?
my lord. In the plain, my lord,
Land belongs to your father, it was
land belonged to father,
bequeathed to you.
it to be.
The
In the-
probate was granted in your favor.
And mother was a witness in the probate proceeding.
Then mother gifted the same property,
The same property along with some other money property of other persons. So he had gifted her to her,
including this property.
including this property.
Thereafter,
Thereafter, probate was granted. Subsequently, after 11 years of granting probate, this plaintiff along with other sisters went for revocation of probate.
revocation of probate.
That was
Okay,
dismissed.
okay.
Then they filed appeal before on this honorable court. The appeal was also dismissed. Now, they after dismissal of the appeal also, they have filed a civil suit.
Civil suit for,
Claiming this property.
on the basis
on
of
the gift deed, on the
gift
basis of
deed.
gift deed.
Okay,
Throughout those, revocation, probate revocation proceeding, and that appeal in the office, they did not mention that about the
gift
gift deed.
deed.
They did not mention.
Thereafter, what trial court did
Trial court had dismissed the suit. They went to first appeal.
on the ground that the person who gifted the property had no title.
No title. He had no title.
Okay. Thereafter,
First appellate court also same finding.
and what substantial question of law has been formulated?
In fact, there is the substantial question of law. In fact, those are not substantial question of law itself. Question of facts. My lord, may kindly see. First substantial question of law. Whether court below committed error by holding that the mother of plaintiff appellant has no right to transfer the suit property by the gift deed. So this is a question of law framed by that. Apparently, mother had no right because she had not had authority.
Now, what is their claim? What the plaintiff is saying regarding will?
Regarding will, their pleading is silent regarding will. But their thing is that we have already got the property by gift. So question of will does not arise. That is their content is that we have got the property by way of this gifted. My mother had right and title because somehow they got the name of mother mutated in the revenue code.
Okay.
Although that mutation was subsequently cancelled. We have filed there was a revenue appeal also, the mutation was cancelled. But by taking mutation, after taking mutation, they have got the gifted. But mother did not have authority to, did not have right and title upon the suit land. So how can she transfer it? Without having a right and title, how can she transfer it? Cannot transfer it. But for execution of gift deed, one person has to be right upon the property. So this point is, I shall refer to judgment of your lordship may go through judgment. Second,
Okay.
whether second Substantive question. Whether a court below committed error by holding that a Hindu widow is not entitled to inherit the immovable property left by her husband.
No, she may inherit if it is not bequeathed otherwise.
But this is nowhere this is finding of any of the court. That Hindu widow cannot inherit.
Okay.
This is nowhere finding of any court. that
Now, in whose possession the property is?
Property in my possession, property were mine.
It is with you.
Only she is in permissive upaya. She is permissive with regard to 1 katha of land. That will permissive upaya. Sister married, she had no house. So by getting mercy and love and affection, I had allowed her to stay in my campus. But that was my mistake that I allowed her to stay in my campus. She instigated my mother against me.
She is having possession over 2 kathas of land.
1 katha only.
1 katha.
1 katha only. That's permissive upaya. Without title, without any right and title.
And as regard that, there is no suit. You have not filed any.
Now, as regards that, we have filed suit. Since
Eviction
there is a bad
suit.
blood, we have already filed suit. The suit is stayed till disposal of this affair. Suit
Okay.
means that-
Okay. Okay, let the other side come.
That is why, my lord, that is why they are not coming, always avoiding. Since last 3 years, they are avoiding the hearing of the case.
Let us see. Let us. Mr. Mondal, you have anything?
Problem is that what if they are there?
Mr. Bhatto? In second half, we have fixed matters. Okay, we'll wait for the. Your item number is? 13 কি কৈছো? Okay, let us wait. I'll come again.
Nine.
Yes.
Sorry for the inconvenience.
No issue.
My lord, this is the second April, my lord. Against concurrent findings, my lord. My lord, title suit 16/2006, my lord, was filed for declaration of right title interest, my lord, by the appellant over a land, my lord, mentioned in schedule, my lord. So that is at page 20, my lord, mine. Appeal memorandum, my lord. My lord, here, my lord, almost 8 bighas of land, my lord, more than 8 bighas, my lord, total. Has been, my lord, that was given by the mother of the appellant, my lord, in her favor by way of a registered gift deed, my lord. And before that, my lord, in 1969, my lord, there was a will granted in favor of the respondent, my lord. By his father, my lord, respondent's father. That means, my lord, appellant's father also, my lord, both respondent and appellant and respondents are brother and sister, my lord. And that is a property, my lord, after division, my lord, after division, ancestral property, my lord. After division of the property, my lord, the will was supposed to be granted, my lord, in favor of the respondent.
And in some of the lands, my lord, in some of the, under some drugs, my lord, which has been given, my lord, in their, my lord, documents or in different exhibits, my lord. Here, my lord, that, which one? The race that gives it, my lord, was granted by the mother of the appellant and respondent, my lord. And that was after the death of the father, my lord, in 1981. Which has been exhibited, my lord, before the trial court. And after that, my lord, it was delivered, the possession was delivered to the appellant and possession was taken.
Which is
It
the
is
suit
accepted.
property?
My lord,
Suit property.
yes, my lord.
The dispute is in respect of which property?
Yeah, in,
There are 3 schedules in the
yes, my
claim.
lord.
Which
Yes,
schedule
my lord.
is the disputed?
My lord, at page 21, my lord, the dispute is in entire A schedule property, my lord, but this is the gifted property, my lord.
Sure, okay.
Yes, my
18
lord.
because 17 lecture.
Yes, my lord. And schedule B land, my lord, that 7 because 17 lessons 2 per are already sold off by the respondent, my lord. And the third one, the schedule C, where only 1 katha of land, my lord, under particular dark 526, my lord. This is under the possession of the appellant, my lord. She has been staying there for a long, long time, my lord.
17 bigha, 7 bigha 17 lectures has been
It's sold off, my lord.
sold to whom?
I-
To
my
other
lord,
person.
Respondent has sold off without the knowledge of the appellant, my lord. Nobody
Okay.
knew my.
So now you are on 1 katha of land.
I am not only 1 katha, my lord, I want recovery, my lord, of the rest of the land because I have no idea, my lord, whom he has sold off, my lord.
From whom you will seek recovery?
That is the problem, my lord. From him, my lord, from the respondent. If he cannot give the recovery, my lord, because the gift deed has not been cancelled, my lord, till now. And the trial court as well as the appellate court, both the courts have, my lord, given the verdict, my lord, rejecting his plea in counterclaim that the gift cannot be cancelled because of a limitation point, on the limitation point. So the gift deed is still, my lord, valid, my lord. So if gift deed is valid, my lord, I am entitled to get the entire property.
No, but before gift deed was executed,
Yes, my lord.
the property was bequeathed by,
Not all, my lord. This is also highlighted by both the courts, my lord. Only few, my lord, only 3-4 dogs are included in the will, my lord. And it is clearly written, my lord, everywhere, my lord, that the property in the will is completely, my lord, different from mine, except 3 dogs.
which 3 dogs?
3 dogs, I'm giving back.
Then why your suit was dismissed by the trial court?
Only on one point, the substantial question of law has not been clearly, my lord, discussed. The substantial question of law, why it is dismissed, because Noreshwari Boissa, the mother of the appellant and respondent, she did not have any right to inherit her husband's property. In spite of she being a class 1 heir, madam. She's a class 1 heir, madam, wife. And after husband's death,
Let me understand.
yeah,
Your mother, Nareshwari is your mother.
yes, madam. Not only my mother, madam, respondent's mother too.
Mother.
Yeah.
She inherited, your claim is that she inherited property from her deceased husband.
Yeah, after the will bequeathed land, besides
The
that,
remaining portion.
yes, remaining portion.
So you are not challenging that portion which was bequeathed.
No, because I had lost it, mine. I had challenged mine. I had challenged the probate also, but I
So
had lost it.
This 1 bigha,
Mine.
this 8 bigha 17 lechas land
my lord.
according to you, falls outside the
Yes.
bequeathed property.
Yes, ma'am.
This property was not
No,
the
this
subject
property
matter
is
of the
in
will.
Not in the will, but the dogs, 3, 4 dogs are in the will, but not the area, my lord. Not the area. And being a Hindu widow, my lord, she is a class 1 heir. And she
So what
inherits.
was the reasoning of the trial court?
Trial could say that she did not have any right title
Why,
interest.
why it came to this finding?
I don't know.
No,
That is the finding, my
then
lord.
there must be some logic, right or wrong. Please.
Because will is already granted and
So
did
trial
not
court held
discuss,
that.
my lord, evidences have not been, my lord, discussed properly. No evidences have been taken into account. Only thing is that will has been granted in his favor. So non-history does not, a mother does
So
not have.
trial court considered this property also the subject matter of the will.
No, my lord. Clearly, even bifurcated also. Can I read it, my lord?
Yes.
The judgment of the trial court.
No, now what is your contention?
My contention is since the registered deed has been rejected, my lord, the challenge, the respondent has challenged the registered deed, my lord, gift deed. That has been, my lord, rejected by both the courts. So registered, according to the registered deed, my lord, I am still the owner of 8 bighas, more than 8 bighas of land under the separate, different acts, my lord. And that specifically, my lord, that 1 katha of land mentioned in Schedule C, my lord, that is where I am my lord staying, and that is mine, my lord. I was given more than 1 katha, my lord, as per the gift deed. That is 4 kathas of land. I was.
And that 1 katha is outside the purview of will.
Yes, my lord. Obviously, the dog is there, my lord. Dog is mentioned in the will, but that does not mean entire property, my lord. The area of land in the will is, my lord, less than what the area of land under the dog number 526, my lord, which is mentioned in Schedule C, my lord.
Okay, make your submissions.
My lord, that was the reasoning, my lord, for rejection. And the court also, learned court also has clarified the whole thing, my lord, in the judgment itself. At page 35, it starts from page 35. And my lord, issues were framed on the, in the judgment, my lord. At page 38, by the trial court, whether the suit is maintainable, 1. Number 2, whether there is any cause of action for the suit, whether defendant has right over the suit land, 3rd. And 4th, whether the plaintiff has right, title, and interest over the Schedule A land, and whether the counterclaim is maintainable, whether the defendants are entitled for decree as prayed for. These are the issues taken. Now, my lord, against that, my lord, there's a counterclaim filed by him, filed by the respondent. And in the counterclaim itself, my lord, he has admitted the fact, my lord, that she has been staying there for a long time. That is that page, my lord. Page 29, my lord. It starts from.
Now you show me the substantial question of law in this case is,
Yes.
first is that whether the mother had right, title, and interest to
Yes. Whether
over the property which she
at the
gifted,
time of execution of the gift deed.
gift deed. Just you show me that
I'm coming to that.
that is beyond the purview of will. The
Yes,
property which was
yes,
given in gift to you was not the subject matter of the will.
yes.
If you are able to show that,
Yes, I'm saying. My lord, before that, my lord, I want to read the findings, my lord, where it is clearly stated at page, my lord, 41.
yes.
my lord, third one, my lord, the schedule A, B, C of the plane is gone through, which is mentioned as follows. Schedule A consists of land measuring 8 bigha 17 lasers 2 poa, covered by, these are the dark numbers, my lord, mentioned in my lord, the gift deed. Under one patta, 191. Schedule B consists of land measuring 7 bigha 17 lasers 2 poas, covered by the same darks, my lord. But as per the dark numbers mentioned in the will attached to exhibit D1, out of the above mentioned 10 numbers of dark mentioned in schedule A means my lord, in my gift deed, A and B, only the land pertaining to dark number 107, 140, 315, and 526 are mentioned. That means these numbers, my lord, these dark numbers 1, 2, 3, 4. The 4 dark numbers are mentioned only in the will. Rest of the dark numbers, my lord, out of dark numbers mentioned in gift deed, these are the dark numbers mentioned in will, my lord. These 4 dark numbers. And in 4 dark numbers, my lord, 526 where I'm staying only in one katha of land. And how much land was there, madam? They have exhibited some documents and in LCR, I think, that is available, madam. Okay, Dr.
What is exhibit D1?
D1 is the will, madam. Will. No, in estimate. Will, my lord, D1. My lord, that is in estimates, my lord, in LCR. I think it's there in the LCR.
P1 failed some. C1. Mhm. Good. To tag me, tag only. Tag it. Yes, what is your submission?
So, my lord, in the will, my lord, in the second page, the area as
Now, what is schedule A land?
A land of the, well, that is the entire land, madam, 8 bighas of land.
Schedule A land is the subject matter of the
Yes, madam,
gift.
entire land.
Gift
Gift.
is the gifted property.
Gifted property.
Schedule B land is,
The land which is, my lord, not under my possession. Only one katha out of, 4
and
katha
Schedule
was sold.
C land is in your possession.
Yes, ma'am. So in the will, my
As
lord,
per that number. In D1,
D1 is the will, my lord.
out of the above mentioned 10 dogs, duly, only the land pertaining. So 526 is mentioned in will.
But area is, my lord, area, there, how much area was there under 526? That is in the will, my lord.
Where is the will?
Will is in D1, exhibit D1, filed by the respondent.
You have an next copy of the same in the, no, in the memo of appeal. Okay.
Supposed to.
Mm-hmm.
My lord, 526, how much land?
D1, D1. That করে দিব। Yes, what is your submission?
My lord, in 526, my lord, it is written in Assamese, Adha. My lord, that is one, how much land was there? 1 bigha, 4 kathas. Out of which, my lord, 1 bigha, 4 kathas, out of which only half of the land, my lord, out of that was willed out, my lord.
You read the what has,
Hmm.
please read what is,
Oh, should I read it?
yes, that portion.
Okay, ma'am.
You are reading D1, exhibit D1, will.
Yes, my lord.
Yes,
will.
please read.
Entire,
The
entire. deed, my lord.
the relevant portion.
Okay, only the relevant
that-
person, my lord. Okay. So, this is in Assamese, Willard Compati, Tafsil.
Which page you are reading?
This is the second page of the will, my lord. Exhibit D1. Handwritten, my lord.
Okay. Yeah, exhibit D1 section, D1, flag করে দিব। Yes, you may read. I will go through it later on.
Kamrup Jilar, Guwahati, something register, Polasbari Thanar, Ramcharani Mojar, Mirzapur, Gotit, I think, Keras Medi, 191 number Pattar, Notun, 526 dash, Adha, that dash Adha, 1 bigha, 4 kathas. And then others, my lord, other dags, 575, Hampuna likhise. That means that Hampuna means a whole land. 1 bigha, 1 katha, 15 letter. 553 dag, Adha, half. 1 katha, I think 12, 1.5 letter. 358 dag, again Adha, my lord, half.
Adha is written in brackets.
No, my lord. Without bracket, my lord. That means entire land, out of the entire land, my lord, half. And only 575 is.
So your submission is that out of the dag number 526, only half was bequeathed.
Yes, my lord.
And in remaining
the
half you
half.
are possessing.
Yes.
Your
Remaining half,
you
remaining, my
one
lord,
cut
I'm possessing.
of the remaining half.
Whereas.
What is there to show?
My
Is
lord,
there any evidence to show
my lord,
that you are,
he has also mentioned in his WS, my lord.
that
He
you
has
are,
written the fact, yes, my
that you are possessing
Yes,
the
yes.
remaining half? Show me.
remaining half land, yeah, only 1 katha of land I'm possessing. But my gift deed says, how much I got it. As per the gift deed, my lord, 526. This
Gift
is,
deed is exhibited as,
yes, my lord, this is exhibited as 1, my lord. In case number 16/2006. The last page, my lord, schedule is given, my lord. All the dags are mentioned. Even the areas are mentioned.
How much was gifted?
Yes, ma'am. 526 dag, only 4 kathas, 10 lessons. Sari katha, 10 lessa. So out of 1 bigha, 4 kathas, I got only 4 kathas, 4 kathas, 10 lessons. And out of 4 kathas, 10 lessons, I'm only occupying 1 katha. Rest 3 kathas, 4 lessons, my lord. That 10 lessons, he is occupying. And that is called Basti land, my lord. He is occupying the thing, my lord. And from 1 katha also, he is trying to evict me. Because I'm also daughter of the owner, actual owner, my lord. So as per Hindu law, even I'm entitled to get it. In fact, all the sisters are entitled to get it. But due to the probate, my lord, we have lost the probate case, my lord. That's why, my lord, this entire whole things have become, it has become a, my lord, big issue. My lord. And both the courts have discussed only that. Not only that, my lord, in his probate case, my lord, he had filed an affidavit, my lord. And I have the certified copy, which is not exhibited by me, neither him nor me, my lord. So that is also, my certified copy is there with me. And there also he has mentioned that an area of 1 bigha 4 kathas 0 lessa of land covered by dag number 526, half of the dag. It is written in English. There is a certified copy. Half of the land, half of the dag. I am not concerned with other dags of the will, my lord. I am only concerned the dags in my gift deed, my lord. Whether he sold off or not, that is not a thing, my lord. But I am entitled to get it since the gift deed is still on, my lord. It's still, my lord, valid gift deed, my lord. So he has neither filed any appeal, my lord, against the counterclaim direction, my lord.
His counterclaim was for what relief was sought for income?
I'm reading it, my lord. I'm reading it. In his written statement, my lord, I have annexed that. The written statement has been annexed. Let me tell you. My lord, at page 23. 23, my lord. At para 27, my lord, is the counterclaim. At page 31, internal 9, my lord. Page 31 in my memo. Para 27. May I read it, my lord?
Yes.
That as regards the alleged gift deed, the defendant number 1 begs to lodge the following counterclaim. That the father of the defendant, late Jaguram Das, the full was the full and absolute owner of the suit land. With other land, he had every legal right to dispose of the property during his lifetime. That after the death of Jaguram Das, so the plaintiff, with a fraudulent intention to grab the property secretly and fraudulently mutated the name of her mother, Nareshwari Boissa. Her mother means his mother also. During pendency of PTS case number 772, taking advantage of her illiteracy, and also secretly fraudulently obtained the alleged gift deed in her favor. The execution attestation of the gift deed are illegal, fraudulent, and the same are denied by this answering defendant number 1. Defendant number 1, counterclaimant, had no knowledge about the execution of the alleged gift deed and no delivery of possession of the suit land took place as alleged. Hence, the defendant number one denies the said execution of alleged gift deed, stated there is a gap, and also the delivery of possession of the suit. The defendant has been possessing the suit land since the line of his life of his father till today. It is pertinent to mention that the mother, Nareshwari Bosso, was not the owner of the suit land. That was the point he raised, my lord. So she had no right to execute the alleged gift deed dated 15/7/81. In respect of the suit, and no delivery possession was made. The alleged gift deed dated 15/7/81 did not confer any right, title, interest, and possession over the suit land. In the above fact and circumstance, it is necessary to declare that the said alleged gift deed is illegal, inoperative, and void in land, and the same is not binding upon the defendant and also upon the suit land mentioned in the said alleged gift deed. And but in how it was rejected, my lord, by the trial court. My lord, at page 48, my lord, of the trial court judgment. Issue number 5. Issue number 5, whether the counterclaim is maintainable. The plaintiff has pleaded in their written statement against the counterclaim that the suit is not maintainable at this stage as it is time-barred. In this connection, the prayer of the defendant number 1 in his written statement cum counterclaim is gone through. The defendant in his counterclaim has prayed to pass decree declaring the gift deed dated 15/7/81 is illegal, inoperative, and not binding upon the defendant number 1 and also upon the suit land mentioned in the gift deed. In this connection, Article 59 of the Limitation Act is gone through, which is as follows. The provision has been mentioned, my lord. Then the next parameter, the last one. Thus, the period of limitation starts from the date when the execution of the alleged gift deed came within the knowledge of the defendant number 1, counterclaimant. The learned counsel for the plaintiff submitted that it is mentioned in paragraph number 10 of revocation application registered as miscase number 385/95 that late Nareshwari Bosso had executed a registered sale deed in favor of the plaintiff, my lord. The defendant had filed exhibit number 4, which is the copy of the judgment dated 8/11/5, passed in MAF number 197/98 before the Honorable Guwahati High Court. The said MAF 197/98 was instituted in the year 1998. The defendant had contested the MAF number.
The claim was barred by limitation.
Rejected. So the gift deed is still valid, my lord. And regarding, my lord, Nareshwari Bosso, my lord, the mother's right over the land, my lord. My lord, at page 41, my lord. Second para. Under issue number 2, my lord, it has been decided. Issue number 3, sorry, my lord. Issue number 3 at page 40, whether the defendant has right over the suit land. The suit land is already under a registered gift deed, my lord. Now, whether defendant has any right over the suit land. Now, my lord, at 41, the second para second, my lord. The plaintiff in her pleading submitted that the area of land mentioned in the schedule of the registered gift deed under different darks are very specific, and the land mentioned in the will differs in respect of some of the darks not mentioned in the will. At the time of execution of the gift deed, the name of late Nareshwari Bosso was mutated in the record of rights in respect of the suit land. After execution of the gift deed, this name of the plaintiff was mutated in the record of rights, but later on the the defendant number 1 cancelled her name and mutated his name. The schedule A, B, C of the plaint is gone through, which is mentioned as follows. So the schedule has been mentioned, my lord, here. And but as per the last one, my lord, as per the DAG numbers mentioned in the will, attached to Exhibit D, out of the above mentioned 10 numbers of DAG mentioned in Schedule A, that is the gift deed, my lord, A and B, only the land pertaining to DAG number 107, 140, 315, and 526 are mentioned. Further, the land mentioned in the other DAG number 86, 164, 323, 353, 551, 547 of Patta number 191 of the Schedule A and B are the ancestral property of late Jagguram Das. And as they are not mentioned in the will, the defendant does not have the exclusive right over the same, excluding other legal heirs. Again, Schedule C consists of area measuring 1 kotha covered by DAG number 526, Patta number 191 at village Mirzapur, Moja, Ramcharani, district Kamrup. So far as Schedule C suit land is concerned, as per Exhibit D1, the land in DAG number 526 measuring 1 bigha 2 kothas 1 lecha is included in the will of which probate is allowed. My lord, that is half of the entire land, my lord, which is not discussed, my lord, which is not discussed at all. The learned trial court did not even notice the how much land has been willed out by his father. Just passed the judgment arbitrarily, my lord, without looking at the evidences we have given, my lord. And then so far as is, yes. Then, my lord, PW1 evidence has been discussed. PW1 stated that she had constructed her own house over 1 kotha of land under DAG number 526 with the financial help from government. But DW1 stated that plaintiff was a permissive occupier in respect of the same, and she was allowed to reside in the house of DW1. The plaintiff had adduced oral evidences so to that effect that she is supported by PW2. Srimati Lakhibala Das, her sister, and her husband PW3, Kandarpa Pathak. But the plaintiff failed to adduce documentary evidence that the said house over Schedule C land was constructed by her, and she is not a permissive occupier. Through this, though this plea was raised by the defendant in the written statement itself, and the land is mutated in his name. So there's next page, 43. Thus, from the above discussion, it is held that defendant has right over that land only mentioned in Schedule A and B pertaining to DAG number 107, 140, 315, and 526. And DAG number and Patta number 191. Whereas, my lord, in Patta number DAG number 526, that is not mentioned how much land was gifted away, my lord, willed out. That is, this is also specific, my lord. That means other my lord, other in land under other DAGs, my lord, in mentioned in gift deed, these should be in my name, my lord. It is clearly explained. Only thing is that 526, it did not notice the area, my lord. Then, my lord, issue number 4, my lord, that is the decision made by the trial court, as well as the same decision has been upheld by the appellate court, my lord. That is issue number 4, my lord, whether I have any right title interest over the scheduled land, my lord. Whether the plaintiff has right title and interest over the Schedule A land, my lord. So that is also discussed, my lord. The Schedule A consists of land 8 bigha 17 kotha and 2 lessas, 17 lessa 2 pua, covered by all the DAGs, my lord, 10 DAGs, 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, my lord. And under the same Patta number, then, my lord, PW1 was again discussed, evidence is discussed again, and there, my lord, Narastari Bhuttal, my lord, her legal right has been, my lord, discussed here in issue number 4. Then, my lord, the PW1 stated that the mother of the plaintiff late Narasari Boysa during her lifetime transferred an area of land belonging to her measuring so and so under Dag number such and such. By executing a registered gift deed dated 15/7/81, Exhibit 1, my lord. And possession of the aforesaid land was delivered to the plaintiff accordingly. At the time of execution of the gift deed, the name of the mother of the plaintiff, late Narasari Boysa, was mutated in respect of the said gifted land, and he said, and they said, should have been the, the said gift was executed without any objection from any side, including defendant number 1. So PW2 evidence is also discussed. The sister of the appellant, Srimati Lakhibala Das, who is the youngest sister of late Jaguram Das, also deposed that her mother died on 15/8/2005, and before her death, she executed a gift deed in respect of land under Dag number so and so. Entire Dags have been mentioned at Mirzapur Moja Ramcharani and transferred the land to Saraswati Boysa. That means appellant, my lord. Then PW1 exhibited the following documents. Exhibit A1 is the certified copy of gift deed dated 15/7/81. 2, Exhibit 3 is the certified copy of will dated 1/4/69. Exhibit 3, yes. Exhibit 2/4/14, other certified copy of Jamabandi, my lord. I have exhibited all the Jamabandi copies, my lord, for the area of land, my lord. On the question regarding the genuineness of the gift deed executed by the mother of the plaintiff, the learned counsel for the plaintiff referred to Section 90 of Evidence Act, which is set out thereunder. So Section 90 has been, my lord, explained. Then learned counsel for the plaintiff cited the following case law in support of the case of the plaintiff, year 1997 Supreme Court. Regarding transfer, my lord, under Section 124 of Transfer of Property Act. There are 2 citations, my lord. And then, my lord, the second para of page 45, my lord. Page 45 is the second para. The above cited case laws are not applicable to the present facts. So that was also an issue, my lord. Whether in counterclaim, my lord, that was mentioned by the respondent, that this gift deed is fraudulent and all. That is why I cited these 2 cases, my lord, whether it was complete, the gift deed was, the transfer was complete or not. But that was not considered by the learned trial court as well as the appellate court, lower appellate court. Above cited cases are not applicable to the present facts and circumstances of the case, as because the main controversy in the present case is not regarding execution of the gift deed. That means execution of the gift deed was right by late Narasari Boysa, or the delivery of possession of the gifted land. It has already delivered. But the question is whether the Narasari Boysa could execute the sale deed in respect of Schedule A land, whether she had right title interest or not.
What sale deed? Which sale deed is it?
In respect of Schedule A land.
No, this para refers to a sale.
Execute a sale deed. A sale deed instead of, my lord, gift deed.
This is a
sale
typing
deed.
error.
Yes.
Okay.
So Section 90 of the Evidence Act has been, 90 of the Evidence Act 1872 is founded on necessity and convenience, because this is more than 30 years old document, my lord. And this has been discussed. And thus, from the above proposition of law, the last parameter, even if it is taken into consideration that the said gift deed is executed by late Narasari Boysa, still the main question which is to be determined in whether Narasari Boysa had the right to execute the said gift deed in respect of suit land, which is an ancestral property, and the part of which is already mentioned in the will executed by Jaguram prior to the gift deed in question. So wrong conception was given by both the courts below. During next page, my lord, 46. During the cross-examination of PW1, Srimati Saraswati Boysa, she stated that her father had not executed any gift deed or will in favor of her mother. That is obvious, my lord. she was not given any will or neither any gift deed by her husband, but that does not stop her from getting, my lord, inherited by the property, my lord, which is not, my lord, given by will or any other way, my lord, to anybody. So I'm not asking for the will's property, my lord. I'm only concentrated in my property, which is given by my mother, which is mentioned in gift deed. So this was the thing, my lord. The properties in favor of the mother in respect of the landed property. The properties mentioned in the schedule are self-acquired property. Where it has come, my lord, once he said, the respondent said, this is an ancestral property, even in counterclaim also. And now court decides whether it is a self-property or not, because he had a brother.
Where is that observation?
My lord, this one in 46, my lord, page 46. The properties mentioned in the schedule are self-acquired property.
Which schedule? All the
Schedule of
schedules.
Yes, my lord, A, B, C.
Is there any evidence to
No,
that?
my lord, no evidence laid by them in counterclaim. And I'm not supposed to do, I have never mentioned that, my lord. This is my father's property, whether it is ancestral or self-acquired. And even if it is self-acquired.
Suppose it is ancestral or self-acquired.
Yes, my lord.
After the death of the father,
Yes, my lord.
all the class 1 heir will get equal shares.
How can a wife be excluded from getting property, my lord? As
But
far-
she will get only one share, equal share.
Yeah, equal share.
She cannot give more than what she
Yes, my lord. But whatever, my lord, land, rest of the land, my lord, that was, nobody had objected, my lord. That was inherited by her because already gifted, that will has been already made, and most of the land has been, more than 13 bighas of land has been taken away by him. Whatever rest is there, my lord, that was.
Rest will be equally distributed among class 1
Should have
heirs.
been, but this was with consent of others, my lord, only sisters. The sisters-
Evidence to that effect is there.
Yeah, sisters have, it is also, my lord, mentioned by the trial court in judgment also, that there was no objection from the sister's side, giving her, because she had looked after her mother after the father's death. That is why she had to stay. That was out of affection, the gift deed has been executed, my lord. Not for anything else. And even if she had not given a gift deed, she was entitled to get father's property along with her other sisters. So she's not claiming all this, my lord. The mother had given. Now, since the respondent is trying to evict her from that one kotha of land also, my lord, without having any, my lord, consideration of as sister, my lord, and he wants that portion of the land also, then only I had to file the case, my lord. Otherwise, I would not have been, my lord, in before this honorable court, my lord. Because I am a daily wage earner, my lord.
So your main emphasis on one katha land over Dag number
That,
526.
yes, my lord. That is, my lord, and my lord, rest of the 3 kathas of land under the gift deed, my lord, should be given to me, my lord, from the respondent, my lord. That is the Basti land, my lord. He is occupying the land, 3 kathas of land, besides all the, my lord, land. That was, my lord. And he, as far gift deed, whatever land is there, my lord, if he has sold off also, he should compensate me, my lord, by way of paying money, my lord. So out of the said, but he did not inform any of us, my lord. He did not inform. He did it solely, my lord. And as per Hindu Succession Act, my lord, I am entitled to get it, my lord. Otherwise also. Otherwise also. And same thing, my lord, here again, again written, my lord, again judgment said, the third para 46, my lord, page 46. Thus, from the deposition of PW1 and PW2, there is no dispute to the fact that the said truth land is the ancestral property of the father of the plaintiff, late Jaguram Das and defendant. Jaguram Das and defendant, and no gift deed or will was executed by the Jaguram Das in favor of Noreshwari Vaishya, transferring the right over the same in her favor. The mother son is more important than the mother wife, my lord.
Okay, thereafter what?
And after that, my lord, rejected. Though the plaintiff had exhibited a copy of Jamabandi and deposed that the name of Naraswari Boissa is mutated in respect of suit land initially at the time of execution of gift deed, and thus she had the right to execute the gift deed. But the same is not sustainable as because mutation does not confer any right. But in that case, my lord, if my lord, no right is conferred by way of mutation by the respondent also. It only enables the person in whose name mutation has been ordered to pay land revenue. Hence, in absence of any contrary evidence, the order of mutation in favor of late Naraswari Boissa does not establish title. Then Father DW1 exhibited the following document in support of his contention that the gift deed also included the property which belonged to the brother of Jaguram Boissa. My lord, neither he had not made Jaguram Boissa's brother a party at the time of filing the probate, my lord, when he got the probate certificate, my lord. Exhibit D3 is the deed of family settlement in 1954. And after this, as per this family settlement, my lord, whatever property the father of the appellant and respondent has got, my lord, we are only on that, not his brother's property, my lord. That does not come up. There is no objection from brother's side at all. That is an ancestral property, my lord. Thus, from the above discussion, it is held that the property mentioned in Schedule A land is an ancestral property of the father of the plaintiff, and it is no way transferred to the late Naraswari Boissa of the plaintiff. Plaintiff has no right, title, and interest over the Schedule A land on strength of the gift deed executed by her mother, late Naraswari Boissa. Then what will happen to the gift deed, my lord? Is it necessary the gift or will has to be executed in favor of the wife? And issue number 1 relates to whether maintainable or not, and defendant's counterclaim has been rejected. So more,
So
my lord,
your submission is that the court failed to take into consideration that
yes,
the father of the present respondent and your father will bequeathed only half of the property in 526.
fine. Only half of this written by
So the entire property was not bequeathed. Therefore, the half,
half is in the obviously when out of the half, my lord.
the remaining half is to be inherited, is to be transferred by way of inheritance among the legal heirs. And your submission is that your mother inherited the same along with other
Yes, ma'am.
legal heirs, and other legal heirs did
Yeah,
not
fine.
object it.
Did not object it.
Therefore, she gifted that half to you.
And rest will property, we don't need it, my lord. They have never asked for it. Will property, we don't need it. And the last issue already I have read, my lord. The last issue, the issue number 5, has gone against respondent, my lord. So counterclaim is rejected and no appeal filed by him, neither before the lower appellate court nor before this court, my lord. There is no kind of pleadings against that counterclaim.
What was the observation of the first appellate court?
First appellate court regarding the counterclaim, my lord.
And even whether how it discussed the matter.
Yes, madam. This was the issue 5, issue number 5 is the counterclaim, whether it is maintainable or not. It has been discussed properly as per Article 59 of Limitation Act. And last one, last para, my lord, at 48, page 48. Thus, the period of limitation starts from the date when the execution of the alleged gift deed came within the knowledge of the defendant number 1, counterclaimant. The learned counsel for the plaintiff submitted that it is mentioned in paragraph 10 of the revocation application, registered as miscase number 385/1995, that late Naraswari Boissa had executed a registered gift deed, here also sale deed, my lord, gift deed, in favor of the plaintiff. The defendant had filed exhibit number 4, which is a copy of a judgment dated 2005, passed in MAF number 197/98 before the Honorable Guwahati High Court. The said MAF 197/98 was initiated in the year 98. The defendant had contested the MAF number 197. MAF 197/98, my lord, we had filed, my lord. The appellant had filed against the probate, my lord. So he was the defendant, respondent was the defendant, and again in High Court, he became the respondent, my lord. As per the exhibit number 4, hence the period of limitation started from the date when the defendant gathered knowledge of execution of the said deed. In view of the above discussion, it is held that the counterclaim is barred by limitation is not maintainable. The issue is decided in negative. Then number 6, defendants are entitled for decree as prayed for. It is seen from the issue number 6 that the counterclaim is barred by limitation, hence the defendant is not liable for a decree declaring gift deed dated so and so is illegal, inoperative, and not binding upon the defendant number 1. So it is binding on him, my lord, and upon the suit land mentioned in the gift deed. So, my lord, this is very clear. Only that point, my lord, Narastari Bussa had any right or right title interest or not. On that issue, my lord, entire case has been rejected. The suit is counterclaim is dismissed, my lord. The order is a counterclaim is dismissed. And nothing else, my lord. And plaintiff is not entitled to any relief rate for. This is the whole thing, my.
How you proved that you had right to give the property? What mean?
My lord, as class 1, my lord, it comes to me first.
No, whether you took these pleas before the trial court.
I had given Jamabandi copy of my lord, and law says.
No. This is a different aspect that you are claiming that your name was mutated in Jamabandi.
Yes, my lord.
And it
I
is
was
a,
forgetting the.
but it is another aspect that you are claiming the property as class 1 heir.
Yes, my lord.
Have
Because
you
that was the
claimed
thing.
before the trial court that
My lord, as the denial is what, my lord, that mother does not have any right.
then have you pointed out before the trial court that
Yes,
a
my lord.
exhibit, then listen to my
Yes,
query,
ma'am.
listen to
Sorry,
my
sorry,
query.
sorry.
The exhibit D1 pertains to only half of the 520.
Yes, ma'am.
Whether that was pointed out,
Yes, my lord.
whether but it is not discussed anywhere.
That was the thing, my lord. It is an
Even the appellate court says that
the appellate court has upheld the same decision, my lord, not discussed differently.
no, even appellate court says that D1 appears to be in respect of 1 bigha 2 katha 1 lecha, entire land, not half. How
No,
much land
How
is,
can it be, my lord, when respondent himself has submitted the document, my lord, exhibited the document, my lord, that document has not seen it, my lord. Nowhere it is discussed, my lord.
yes,
So what is the area of land? And we have given enough documents, my lord, including the mutation. If mutation is not important, my lord.
but
it is
your
important for
mutation was cancelled.
Yes, my lord, cancel. After the process is granted, my lord. We fought for that. Then only we filed the case, my lord. That was in 84, I think. So that is the whole thing.
Now you are possessing the land without any
Without any-
mutation order. Your name is not there in Jamabandi.
This is pending, man. Pending for a long, long time. Man. That's why I cannot even approach the circle officer. And I have not won the case, my lord. I have lost in both the courts, my lord. Only on the same issue, my mother did not have any right. So not only that, my lord, that because she had rights, she was possessing, she had inherited. So that cannot be denied, my lord.
No,
As per
but you have
section-
not claimed this in your plane, that you are, you have inherited that from your husband,
No,
your mother inherited.
6-5 time back, my lord, before I filed the case. So she cannot do that. I
No,
have
no.
submitted the documents, my lord. That she had right
No,
at the time.
my query is, in your plane, have you pleaded that your mother, being class 1 year, inherited the
She had
properties which she have gifted to you by way of inheritance? This pleading is not there.
Can I take that pleading, my lord? That is the law, my lord. The law cannot be pleaded, my lord. So my pleading
No,
is that
no,
my
that-
mother had right.
That is not the law. Your
Of
mother
course, my
has
lord, she-
inherited is the fact.
Thanks. Can I show the, my lord? Hindu Succession Act, my lord. Schedule, my lord.
No, no, I am not disputing the law.
So
My only query is whether there was
I-
any pleading
there is a pleading, my
that
lord.
by way of inheritance, being a class 1 year, your
Mention.
class 1,
Have to mention. I am a class one.
okay, by way of inheritance,
Yes, I got it.
where?
In my plain.
Plain.
I'm giving my lord.
Your
So
mother go.
section 10 itself has said how it should be distributed, my lord.
No, that is the law. Law,
That is the law.
I'm
I
not
cannot
disputing.
My plead law in my plaint, my lord.
No, please understand my query.
So I understand, my lord.
I am
Yes.
putting it again.
Okay, my lord, I understand, my lord.
The, is there any pleading in your plaint
Yes, my lord.
that the property which was gifted by your mother to you
Yes, my lord.
was inherited by her from
Yes.
her late husband? Is there any pleading
Yes,
that
I definitely, my lord.
this will help the court to decide whether your mother has right or not?
My lord,
Because the trial court and first appellate court have only stated, have only reached the conclusion that your mother was not having the right of
on what
gifting.
basis, my lord, they have decided?
No, that is my
On what
question.
basis? If I have not mentioned, suppose I have not mentioned about the, that pleading is missing, but my entire claim is on the properties mentioned in the gift deed, my lord. If the question comes before both the courts, that whether the donor has any right title interest, who has raised that question, my lord? Only the respondent, dependent. So dependent could not, my lord, prove that thing. How could he prove that? He had given only his document. This is willed out. This is, my mother did not have any right. Only that much he did it. So why should I raise a question which is not, my lord, important for me to claim, my lord? If mother's question comes, my lord, obviously my case will be different, my lord, in a different line. I only understand that gift deed is a registered gift deed, my lord. It is still valid. And since it is not rejected by any court before I filed the case, my lord, neither the respondent has filed any objection against it gift deed in spite of his knowledge in 1995, my lord, which is mentioned by the court itself. So how can I claim, my lord? My mother's right, if I have to claim, my lord, then my case would have been in a different direction, my lord.
No, no.
And she had to be then, she had to be brought before the court to prove herself that I had the right, but she died already. Then only, my lord, complication arose, my lord. After her death, as long as she was alive, my lord, there was no kind of question of eviction of the appellant, my lord. After her death, my brother has started out disputing, my lord, and quarreling, and also fighting with me to evict me from the 1 kotha of land, and rest is, my lord, he is not going to give me anything. But he should be punished for selling the land which is not his, my lord. And if this thing, my lord, the mother's right has to be proved, my lord, then all Hindu mothers will be, my lord, will be having a different kind of, my lord, situation.
No, no, no. That is not my query.
But
My
this
query is, you are claiming the Schedule C property,
all
A property,
executed, my lord.
on the basis of a gift deed.
Yes, that to raise
And
that.
the court held that your mother did not have right to give that property,
ma'am.
as she did not have any right, title and interest
Yes,
over the
yes,
said
ma'am.
property, which
When
she,
did they get it, my lord? That point has been proved, my lord, not proved. Only on the basis of the pleading made by the respondent. Isn't it biased, my lord, and arbitrary also? because it was not even an issue, my lord.
No.
The issues are different, my lord.
Whether trial court is right or wrong, we'll decide. But trial court as well as appellate court observed that whether
That I understand.
that
Mother has no
the
right.
mother has no right as
Yes.
because the property has already been bequeathed to son.
I have explained to that, my
Okay,
lord,
okay.
how much land is left out, my lord, after giving away. And one more thing, my lord, that issues have been framed by the court itself. And there is not a single issue, my lord, which says that whether Nareshwari Bussa had any right title interest over the gifted land, my lord. There's no issue. An issue whether respondent has any right title interest over the Schedule A land. That was the issue, my lord. Ulta, my lord. And that issue, they have decided she did not have, the mother did not have any right. How can it be, my lord? If that issue had been framed, my lord, I'd have given my lord lot of evidences, my lord. I have evidences, but that was not at all, my lord, subject matter of the entire suit, my lord. Suit is registered according to
Okay,
registered
this
gift.
plea was even not raised by the defendants
my
that
lord.
the mother did not have any right to give that property.
Nothing, my lord. Nothing, my lord. All of a sudden that had come because he said the mother did not have any right. How can it be, my lord? It is a violation of Hindu Succession Act, my lord, section 8 and 10. It's a violation, completely defective, my lord, the both the judgment, my lord. So should have got
Okay,
her,
yes, Mr. Anything else?
my lord.
Anything else?
My lord, I just, my lord, your lordship is well aware
Yes, Mr.
about the section 9 and 10 of the Hindu Succession Act, my lord. After she gets it, my lord, inherited her husband's property, my lord, that becomes a street according to section 9. And students, she can do it anywhere. There is no objection from other children also. So why did you mutate your name? My lord, in different Jamabandi copy also it is mentioned properly, my lord, that Nareshwari Bussa had inherited entire property of her husband. And after that only, my lord, when probate was issued, my lord, then only he got it
But
cancelled.
she cannot inherit entire property.
Yes, but that's
Even if she is
doesn't
a
matter.
class
my lord.
one,
I have given up, my lord. Whatever will property is there, my lord, I would have said yes, my lord. Say, okay, will property, you take it since the court has given you,
yes,
but
Mr.
not the rest of the property, my lord.
Mr. Sharma.
How like that?
My lord. In fact,
How much land was bequeathed to you in Dag number 526?
in Dag number 526, whatever was the property of my father, that had been given to me. In Dag number 526, there was two parts. One share was share of my uncle, and one part was share of my father. So father's share bequeathed to me, and we have
Therefore, the word Adha is there.
Adha is there. Therefore, the word Adha is there, and we have exhibited that document, my lord. That document had been exhibited by him, and the court has discussed that document also. In fact, in between my father and my uncle, there was a partition by panchayat in the village. There was a panchayat in village, and by way of that panchayat in village, there was partition. And in view of that partition, half of the property remained with my uncle, and another half remained with my father. So my father's share, the half of my father's share, that has been bequeathed to me. So that is why mother had no right to bequeath, not to gift any property.
Now, how will you interpret that word Adha in the will? In the will, it is
It
mentioned,
means it will in the half of the entire dag.
but
Half of the entire dag. Half of the entire dag.
and remaining half,
Remaining half went to my uncle, Sonuram Elias Bhakeri. That is a that has been exhibited by us. But that document, and that document has been discussed by the trial court also. And yes, madam. This was exhibit D3. That was exhibit D3. And that was discussed by trial court also.
now where trial court has discussed, show me.
And very surprisingly, they did not make the Tanuram also party in the case. Neither Tanuram was made party in the case, nor his legal were made party in the case. And his share was also, mother has not only gifted my share, that was that bequeathed property, but also the property belonging to Tanuram. Tanuram's property was also bequeathed by me. That is the main point. I mean, this is the judgment of Tahir. First of all, I would like to point out the plain fact. Regarding non-gender of participant. Even if there would have, the entire property would have belonged to my father.
No, we will confine ourselves to the substantial question of law. The
Okay.
substantial question of law is as to whether
Court committed error by
the,
holding that mother of the plaintiff appellant
has
had
no
no
right.
right to transfer the suit property by gifting.
so, that one and second one.
Second one, I think
So
second one is
her
that the-
submission is that even if the will is probated and property is bequeathed to you, the Dag number five, only half of the Dag number 526 was bequeathed to you. Other half has been inherited by her mother, which was gifted to her. What is your submission?
that is why I said that in view of partition between my uncle and my father had got only half of the
No,
Ragnar property.
is there any such observation in the
My lord.
judgment?
Will be issue number 4. Issue number 4. Whether plaintiff has right title interest over schedule A land. Schedule A land consists of Dag number 8 bigger 17 lesser and covering Dag number 86, 107, 140, 164, 350, including 526 and 547, etc. And patta number 191. Then here it one. That it is page 46, my lord. Running page 46, my lord.
Yes.
Let us see from page 45, last part. Page 45, last part.
Yes.
Page 45. Thus, from the above proposition of law, even if it is taken into consideration that the gift deed is executed by late Noreshwari Basho, still the main question which is to be determined is whether Noreshwari Basho had the right to execute the said gift deed in respect of Footland, which is an ancestral property and part of which is already mentioned in the will executed by Jagyaram prior to gift deed in question. Then, during proceeding on PW1, Srimati Saraswati Basho has stated that her father had not executed any gift deed in or will in favor of her mother in respect of his landed property. The properties mentioned in the schedule are self-acquired property. Her father had another brother, Tanuram Das, who expired. This is another brother, Tanuram, who is expired now. The heirs of Tanuram Das has also got land in Patta, land in the Patta. Tanuram Das is also called the name by the name of Bhakheri. So it is admitted position that Tanuram has also his share in the land. He is also called Bhakheri. PW2 in her cross-examination also stated that Tanuram Das also inherited ancestral property equally. It is their witnesses. who are admitting. Her father did not execute any gift deed in favor of her mother. So Tanuram had also executed.
No, but the PW1 says that the property mentioned in the schedule are self-acquired property of her father.
It says self-acquired, but this is also there is ancestral property. The fact is that there is ancestral property. That is an admitted position. Admitted position of fact is it is ancestral property. And she also said the properties mentioned in schedule are self-acquired by her father and another brother. Even if, let us assume self-acquired property, even then, her father and Tanuram Das was expired. The heirs of Tanuram Das also got the land in Patta, in the same Patta, Tanuram has right side. His legal heir says right. His legal heir says also right. Then PW2 also clearly admits it. Thus, from the deposition of PW1 and PW, there is no dispute to the fact that the suit land is ancestral property of father of the plaintiff, late Jaguram Basya, and the defendants, and no gift deed or will was executed by Jaguram in favor of Nareshwari Basya, transferring his right in over the same. Though the plaintiff has exhibited copy of Javamandi and reports that the name of Nareshwari Basya was mutated in respect of suit land initially at the time of execution of gift deed, and thus she had right to execute the gift deed, but the same is not.
No, is it your case that your father bequeathed entire property which he falls within
Yes.
his share,
Yes,
leaving nothing
he gifted.
for other
Yeah.
legal heirs?
He is gifted with entire property, and in fact, I was looking after an entire family after death of
No,
my father.
where is that statement in your written statement?
So, yes. The DW1 exhibited the following document. It was important. This is important. DW1 exhibited the following document in support of his contention that gift deed also included property which belonged to brother of late Jaguram Basya. Exhibit number D3 is deed of family settlement dated 1954 of the properties between father of DW1 and his uncle.
What is there in D3, we don't know. It is not discussed.
Thus, from the above discussion, it is held that the property mentioned in Schedule A is the ancestral property of father of the plaintiff, and it is in no way transferred to let Nareshwari. Thus, plaintiff has no right title interest over the Schedule A land on strength of the gift deed executed by her mother, Nareshwari. So,
No, how that conclusion is arrived. Suppose it is ancestral property of her father.
Right.
After death of the father, the mother, Nareshwari Das, would also inherit at least some share,
yes, of course.
her share.
There were 10 legal years. Out of 10 legal years,
She would,
also
1 by
inherit
10,
1/10
1/10.
share. She would have got 1/10 share.
Yes.
She would have got
So
1/10 share.
this,
But in view of the gift deed executed by father, and admittedly, it is a position that they have also admitted, PW is also admitted that Tanuram Basya was also having his right and title. About the children. They are equal share. Tanuram Basya was also having equal share in the Patta. So only half share of land is my father's land. And your lordship has rightly pointed out other way also regarding that Dag number 526, which is exhibit C. What had been gifted? Entire plot of land measuring 2 kathas something has been gifted in the gift deed. Whereas father got only 1 bigha something got. Half of that father got. But what is gifted? Entire land. Whereas she should have got share from my father. My father says, out of my father's share, she could have got 1/10 share. My father gets half share. My lord, we have exhibited D3, exhibit D3. That exhibit D3 was not challenged by them. My lordship, if wants to see the evidence that can be seen, my lord.
no, but D3 has not been discussed by the trial court.
D3 has not been
Mayor statement that D3 has been family settlement has been exhibited. What is the impact of that family settlement?
Yes. Court has applied this mind, that is another thing. Court has applied this mind, my lord. Then D3 there. So they have also admitted that half of share goes to Tanuram. They are also admitting the share of Tanuram is there. PW2 clearly say that yes, Tanuram got half of share of the land, entire patta, half of share. So that is an admission on their part. They cannot escape from the admission. So what is left, half of share of the property is my father's property, and my father has gifted the entire property and entire.
Where is that street?
WS. By lot. Otherwise also, the suit cannot be maintainable. They did not even implement any of the legal acts of Tanuram. They are claiming entire patta land, entire patta had been gifted to by mother to them, excluding the Tanuram, and they did not implement even Tanuram the case. We have taken specifically the Tanuram or his legal heirs are a necessary party in the suit. They did not agree. So without presence of Tanuram, can the suit proceed? Can a decree be passed, executable decree be passed without implementing Tanuram or his legal heirs? Where
No,
mother
regarding
is-
maintainability, what the court held.
that can be seen by this honorable court at this stage also because it is law point.
No,
whether
but you have not challenged the question of maintainability of this.
My lord,
The finding of the trial court.
Hmm.
Trial court held that suit is maintainable.
problem.
Cause of action is there.
If a suit goes in favor, I cannot challenge the decree. That is another thing. But cause of action, trial court, yes, trial court said, yes, there is cause of action. Trial court said that, yes, there is cause of action. Regarding non-gender party, no issue has been framed.
No, in second appeal, we will not go into all issues.
No, that is why. Regarding
Only
non-gender-
you show that in your written statement, you have pleaded that the entire property of your father was bequeathed to you by exhibit D1. And therefore, the trial court was correct in
Mhm.
holding that Nareshwari Devi did not have any
Right.
right title in.
Yes.
The A1 files also.
In this connection, the dependent back in para 14, my lord. Page 26, my lord. In this connection, the defendant begs to state that half of the portion of Basti land was fell in share of younger brother of Jaguram Das. And the second half.
Para?
Para 14, my lord. Here how the pleading is built, my lord.
Page number?
Page number 26. Page 26.
Yes.
Here the pleading statement. In this connection, the defendant begs to state that half of the portion of Basti land was held in the share of younger brother of late Jaguram Das, and the second half portion of the Basti land has been possession of Tanuram Das, the younger brother of the Jaguram Das. And after partition between two brothers, the other half portion of land in Dag number 526 Patta number fell in the share of Jaguram Das, which land is now under occupation of defendant. It is pertinent to mention the plaintiff was married away to one Pandro Patak, but after marriage, the husband of the plaintiff had no land, so he is allowed to give him. So another half is was given to me. Only half of the land of 526 was the share of my father.
You have annexed the judgment of the probate court,
Yes, my lord.
exhibited probate court's judgment before the trial court. Which exhibit? Whether
Exhibit number D1.
D1 is the
D1 is the probate
probate, no,
of the will.
the judgment.
Then regarding Then another exhibit is my mother has adduced evidence in my favor in the probate case. My mother has supported the will. That is also exhibited by me.
Noreshwari,
Sorry. She had supported the will executed in my favor. That is due to PTS 7/72. She had adduced evidence as a witness in that case, supporting the will. She supported the will. Then we have annexed the copy of judgment in MF. MF, my lord, we have. The MF filed by them had been dismissed, my lord, by this honorable High Court, my lord. That is D4, exhibit number D4. So even, my lord, the Jamamandi, my lord, Jamamandi of the land, my lord, that we have exhibited, my lord. Jamamandi of the land exhibited by us. That is exhibit D9.
do you have English translation of the will? Anywhere you have
Your
exhibited?
lordship require, I can translate it. Usually I am not able
Will
to
to
read
the
possible, my lord. Exhibit D9 is the Jamamandi, my lord. It clearly shows name of two brothers. Jojuram Saw and Kanuram Saw. Kanuram Saw is his name is Pakeri.
Now you want that 1 kattha land from your sister.
My lord, problem is that, my lord, if relations would have been better, good relations, there have been good relations, then 1 kattha is nothing, we could have given in 1 bigha also. But she had betrayed the brother behind back, my lord. We had allowed her to remain with
No,
us.
she has
We had
betrayed
invited
my-
out. I have brought her. I have, as an elder brother, I have brought her. She manipulated my mother and tried to evict me from entire plot of land
Where is the-
by getting a gift deed. She tried to evict me. So now, those sentiments, my lord, I would have given him 1 bigha, not 1 kattha, 1 bigha. But now it is problem is that
Then give her now.
no, my lord, problem is that,
My
my
lord,
lord.
he is above
Firstly,
law, my lord.
no.
He is above law. He is out
No,
of
no, not above-
revenge,
not-
my
not
lord. out
above
of
law,
that.
not above law. We want to
He
go
will
to the-
decide.
as per law.
So my sister has.
Now, if law gives him something, that is another thing. But problem is not, it is not a,
Any other submission?
my lord. So my submission. Up to
My
date, my
lord,
lord.
I have a little.
Up to
submission.
date,
Okay,
my
we'll
lord.
continue at 2,
At 2, my lord.
after lunch.
13, my lord, several cases, my lord, has 2, my lord. So, my lord, I don't have the consent of the appellant side, my lord. Myself, I responded. Maybe take on any other date, my lord.
13 is part heard?
No,
No. Okay, 13 due to paucity of time. Heard Mr. S. Chauhan, learned counsel for the
Respond.
respondent, and Mr. K. Bhatto, learned counsel for the appellant. Ulta ke likhibo. Appellant agot line. Due to paucity of time, this matter could not be taken up for hearing. Let this matter be listed for hearing on 5th of March. February 2nd we could do. 12th February. We will continue after lunch.
Hello, in the morning, in the last shift, the item number 16 call for. My colleague has took time at 2 p.m. Hello, only that case is already heard. Today is spot to submit the written argument and along with sir. So may I submit?
Okay.
And
Item number 16.
16, my lord.
Both of you have.
No, I am.
No, no, my, Mr. Talukdar is.
Okay.
So I refer 7.
Item number 16. Heard Mr. R.C. Paul,
my lord.
learned
Appellant.
counsel for the appellant, as well as Mr. A.R. Talukdar.
Ayat Talukdar.
I.A. Talukdar, learned counsel for the respondent. Both the counsels have filed their written gist of argument as was directed by this court on earlier occasion. Let this
Maybe.
the judgment is reserved.
My lord, I'd like to mention item number
My
12,
lord,
my lord.
I'm giving some question also for decision. There is a fourth question.
Okay, okay.
Because it is earlier this claim petition was.
Hearing concluded.
My lord, my lord. Much obliged.
Yes.
Item 12, my lord. Actually, I am in legs in court number 14. So may I pray accommodation for the day, my lord? If date may be fixed any other day, my lord.
Heard Mr. S.K. Ghosh, learned counsel for the appellant. Also heard Mr.
S circle.
S. Sarkar, learned counsel for the respondent. Learned counsel for the petition appellant has prayed for an adjournment as he would be busy in hearing
Court number 14.
Pathan matter
No, it is going on.
in other court. Considering the submissions made by learned counsel, the prayer is allowed. Let this matter be listed again on Putuleta date due, 5th of February.
Much obliged.
Item 9.
Item number 12. Item number 12. Yes.
That's fine. My lord. In the pen, my lord, right? In the pen, what is their prayer, my lord, in the pen? For declaration of right and title, interest over the plate of the plane, over schedule A plot of land. Schedule A plot of land. Schedule A plot of land for declaration of the right and title. And that schedule A plot of land. And that schedule A plot of land is also not specific. How much land in which task? Not clear. Number one. There has to be specific. In that number 56, how much land? That number 164, how much land? That number 526, how much land? Not clear. It's not clear.
Yes.
How the degree will pass on that point, number one. Number two, they have also paid for recovery of position of schedule B plot of land. Recovery of position of, that they are not paying for recovery of position of 1 cut of land. They are not paying for 1 cut. They are recovery of position of the schedule B plot of land. Entire land.
7 bigger.
Entire land. Recovery of position of entire land. Not only 1 kata, entire land.
In whose possession the said land is now?
And now they said that I have sold that land. To whom I have sold? Whether those persons are made party in the case?
Argument should have been, my lord, on
Mhm.
substantial question of
Mhm.
law.
That is very coming, na? Actually,
Substantial question of law.
actually,
my lord.
it is not a substantial question of law, it is a
Not
question of, fact. It is
evidence,
question
my
of facts, in congruent finding of fact. They have prepared a question of facts, my lord. Whether the court we committed error holding that mother has no right and title of estate. It is a question of fact, not a question of law. That is a question of fact. Question of law will be different thing. Question of law, my lord, repeatedly our Honorable Supreme Court held, what is the question of law? It's a question of fact. If the finding, some question, law point, if the finding is wrong in some law point, they could have exited this finding in this law point is incorrect. But now they have prepared a question of fact, not of law, my lord. My lord, I am submitting to decisions of two decisions of the Supreme Court, my lord, in this regard, that they have exited here. Whatever they have prepared is question of law, that is a question of fact. If the lordship wants to decide upon it, whether the court below committed error by holding that mother of plaintiff has no right and to transfer the property. in that case, your lordship will have to go through the evidence of the case. Without going to the evidence of the case, this question cannot be decided, my lord. So this is not a question of law. Definitely, your lordship, definitely we have to go to the evidence. Without going to the evidence, this question cannot be decided. So, my lord, these two, what is substantial question of law in 2025, could also,
Which para you are relying?
my lord, para, page number 5, my lord.
First judgment, Rabindranath.
Yes, my lord. It is Rabindranath. It is AR online 2022. AR online 2025 SC.
Yes, which para?
Rabindranath. Okay,
Para?
Para number, which para number? I have marked para. Para 7. Para 7, my lord.
Okay.
In present case, the question as framed by High Court in our view does not meet the criteria of substantial question of. For a question to be substantial, reference can be made to the discussion made amongst the host of other judgments. That is, when a question of law is fairly arguable, where there is a room for difference of opinion on it, or where the court thought it necessary to deal with the question at some length and discuss alternative views, then the question would be a substantial question of law. On the other hand, if the question was practically covered by the decision of highest court, or if the general principle of applied to determine the question as well as settled, the only question was of applying this principle, the particular facts of the case, it will not be substantial question of law. Then the court laid down following test, a proper test for determining whether a question of law raised in the substantial. The proper test to determine whether a question of law raised in the case is substantial would be, in our opinion, that whether it is a general public importance, or whether it directly or substantially affects the right of parties, or if also whether it is either an open question in the sense that it is not finally settled by court or by the Privy Council or by the federal court, or is not free from difficulty or calls for discussion of alternative view. If question is settled by highest court or general principle to be applied as well as settled, there is mere a question of applying this. To be a substantial, a question of law must be debatable, not previously settled by law. So a law point should be there. They could, if they would have wrote the law point, whether the in spite of bill, mother can have right. That is another thing, according to such and such. It's not a substantial. They have what a question they have framed, that is a question of fact. This question would have been framed in the first appellate court, not before the High Court. It is a question of fact. So if you want to decide it, I have no objection. I can go to the facts, my lord. It is up to your lordship. Then similarly 2006 5 SCC, my lord. And this is, my lord, against concurrent finding of fact. In concurrent finding of fact, the case, this case is against concurrent finding of fact. They are going to the all factual parts, my lord. Even question of law, section 100 says not only question of law, it should be substantial question of law, not only a question of law. It has to be substantial question of law. But they are raising, that is raising a question of fact, my lord. In 2006 5 SCC, my lord. 2006 5 SCC, my lord.
Yes.
Page 555, my lord. Where 24 will be relevant, my lord. After discussing all these things, my lord, the court says, para 24, my lord. An inference of facts from the recitals or contents of a document is a question of fact, but the legal effect of terms of a document is a question of law. Then the High Court should be satisfied in the case involves a substantial question of law and not a mere question of law. Mere question of law is not sufficient. Substantial question of law should be there. You also will go to it, madam. Number 3, the general rule is that High Court will not interfere with the concurrent finding of courts below, but it is not an absolute rule. Definitely concurrent finding of fact can be interfered, my lord. Some of well-recognized exceptions are where the court below have ignored material evidence or acted on no evidence. So if they would have taken a law, question point that the court below had ignored the material evidence on the court, or the finding is perverse, that would be a different issue. The courts have drawn wrong inference from the proof facts by applying the law erroneously. The courts have wrongly cast the burden of proof. It is all that is in that case also it will be there. So my first submission is that that is not a whatever they have framed is not a substantial question of law, my lord. That is a question of fact. Question of fact. In that case, my lord, if my lord wants to go to the case, I have to go to some facts of the case, my lord. Facts have to be argued before the court because they have felt that court below are in holding the mother of plaintiff applicant had no right.
You have already taken the court through the facts.
That is right, my lord. And secondly, my lord, another thing is that, my lord, this honorable court will definitely see that although no issues are framed by the court below, but can a decree be passed in their favor without making necessary party in the case?
Okay, no repetition.
No repetition. That
You have made your
that is-
this submission.
Sir,
and
sure.
Any reply?
I'm giving that, my lord. Thank you. No, I'm not completed.
Anything else?
My lord, why, my lord? They have prayed for recovery of possession. They say that in their pleading, they said that the property has been sold to some persons, but those persons are not before this honorable court. Admitted position is that Tanuram Das was also patta holder. He is also patta holder, half of the shareholder. He is half of the shareholder, but he is not made party in the suit. And his property is also, they have sold his property also by way of gift deed. Tanuram Das property has been also sought for by way of gift deed. But Tanuram Das is not there. So the two important parties are not there. Firstly, Tanuram, and secondly, the person in whose favor sale deed has been executed. And those sale deeds had not been challenged also. There is no challenge to those sale deeds. So how a decree can be passed in their favor on the basis of that gift deed, my lord? Then, my lord, one question was put by this court, my lord. One question was put by your lordship, my lord. Regarding 526, tag number, 526, rewind tag number 526, your lordship has asked the question, my lord. So for that question, my lord, the will, my lord. In the will, my lord, I have been bequeathed half of tag number 526. That is 1 bigha, 3 katha, 1 lesser. And my lord, they are also aware that my father's share is 1 bigha, 3 katha, 1 lesser. That is why in the gift deed also, that is their exhibit, my lord. I write point of their exhibit, my lord. Will is, my lord, exhibit number 1. D1, exhibit number D1, my lord.
Yes.
Exhibit D1. And in their gift deed, my lord, executed by mother, she had also donated, she has also given in gift plot of land measuring 1 bigha, 3 katha, 1 lesser. Out of total land, 3 katha, 3 lesser. Of that, 3 bigha, 3 katha. Of dag number 526. So out of dag number 526, she also given her husband's share. She also know that 1 share of
And other half was
Tanuram
Das,
Das,
as per family settlement.
as per family settlement. Family settlement has not been disputed. She agrees in the cross examination. She agrees to family. Yes, there was a family settlement before my death, before my birth. She agrees the family settlement was there. That is their agreement. So At 26, what has been gifted? Her husband's share. And another thing is that, my lord,
Her husband's share, which according to you was already bequeathed to you.
already bequeathed to me.
Okay. Anything else?
Then
These,
another thing. That is, that is one of the- another thing, my lord. Got her name mutated in the revenue roll.
mutation was cancelled subsequently.
That is what I said. One mutated her name as a legal heir of Jajuram Das. As a legal heir of Jajuram Das. That means she wants to inherit the property of Jajuram Das, not of Tanuram Das. Tanuram Das, she cannot have inherit the property of Tanuram Das. Whatever property she had, although she had
And why the mutation was cancelled? Because
already
the
Jajuram Das property
will was probated.
already be by property. And in fact, in the will, I have already pointed out, so mother has everything in my favor.
Okay.
So the property which was the share of Jaguram Das, that entire property had been given in will to me. And there remained nothing. So her mutation as legal heir of Jaguram Das, that is what was illegal. And after mutation, she had gifted the property in favor of the daughter, entire property. If my father had given entire property to me, he had taken entire property from mother. That is illegal, my lord. And then not only he had incorporated the property of father in the gift deed, he had also incorporated the property which was because of the share of Tanuram. Tanuram's property was also given
This
without
are-
making Tanuram a
This
party.
you
in
are
the gift.
repeating for the third
Now, that
time.
is why, that is so. So the gift deed, now they say that their contention is that why mother cannot have the share, mother have also share in according to class 1. This is class 1, that is irrelevant argument.
No, I have understood your submission that after bequeathing of the property to you,
Hmm.
nothing remains to be inherited by
Nothing
mother.
remains.
That is your submission.
But
And therefore, the trial court and first appellate court's decision is not perverse.
Not perverse.
That is your
that's
submission.
about it. But I would like to just point out a few small portion of the evidence cross-examination of the plaintiff.
What you want to show?
Just only that regarding the shares of etc. Just a part only, not on length. I will not go in length, okay? Only because they have raised a point of my lord. He said, madam, my father had another brother, Tanuram
Whose
Das,
testimony you are taking?
Saraswati,
EW?
PW1.
What you want to point out?
My father had another brother, Tanuram Das. Tanuram Das he died. The heirs of Tanuram Das also got named in the same suit patta in the suit patta. I have not met heirs of Tanuram Das parties in the suit. Tanuram Das is also called by the name Bhakeri. So Bhai Bhakeri, my lord, because in the family settlement deed, name of Tanuram Das was given, it is mentioned as Bhakeri. In the family settlement deed,
Okay.
Tanuram Das name is mentioned as Bhakeri. So he admits that his name is Bhakeri. The properties of my father and Tanuram Das was partitioned amicably with the intervention of village elders. That is admitted. He admitted it that was partitioned. I cannot say the dark which fall in the name of my father and that to Tanuram Das. Since the partition was during my childhood, as such, I cannot say which parties shared with his share. Then others say that by gift deed. 1, 2, 3, 4, 5, 6, 7th line again. By gift deed, my mother gave half of the land of some dogs and complete land of some dogs. I do not know for whom my mother has left the remaining land. Of some dogs, she has given half share. She knows that yes, this half share belongs to my husband. But out of some dogs, she had given the entire dog without caring for the Tanuram Das. That is pain problem. That is why the trial court did not. And another, my lord want to say something.
No, I want to say you have to conclude
It's not-
because we have,
I understand, my lord. Then, my lord, regarding one argument was made that my counterclaim by
dismissed.
that will have no effect upon it. My lord, counterclaim was to declare the cancellation for cancellation of the gift deed. But the courts below came to conclusion that she has no right and title on the basis on the property on the basis of the gift deed. So gift deed
Okay,
is nullified, my lord.
okay. Any reply?
My lord, regarding exhibit three, D3, the division, my lord, family settlement of 1954.
Yes.
Not a single DAG number mentioned here is, my lord, mentioned in the will, neither in the will nor in the gift deed, my lord. Not a single one. It is not matching at all. These are the different DAGs and pattas of father of Jagguram, my lord, and Tanuram. These have got no relation, my lord, with the gift deed as well as with the will, my lord. And regarding, my lord, DAG number 526, my lord, 526, my lord, that is in exhibit 2, my lord. Exhibit 2. Against 526 is a self-acquired property and it belongs to Jagguram only, not Tanuram, my lord. There is no division with Tanuram, my lord. The Jamabandi copy says, my lord. And the area is, my lord, 3 bighas, 3 kathas. That is why, my lord, the half is mentioned in will. And out of half, my lord,
In D3, 526 is not mentioned.
no, my lord, not at all, not a single DAG number, my lord. Not a single DAG number of will or dog gift, my lord. These are all different DAGs, my lord.
Okay.
They're trying to mislead the court, my lord.
My lord, I must say, my lord, it is very objectionable thing. They are misleading the court.
My lord,
In the-
I have
in
not
D-
filed
in
this
D3, my lord,
document, my lord.
In D3, my
I
lord,
have not filed this
it
document.
is of 1965, my lord.
There is
Old
no-
DAG, new DAG.
there is no evidence on this
Yes,
document, my
there
lord.
is-
There is no evidence adduced by
Documents.
my lord.
Old DAG and new DAG. I can show your lordship that is old DAG and new DAG.
But you
So,
did not
I-
show,
I
no?
can show your lordship that is old DAG and new DAG.
Before the trial court, this was not proved.
Was proved.
And my lord, exhibit 2, my lord, 526 DAG, my lord, only Jagguram's name was mentioned. And area is very clear, my lord, 3 bigha, 3 kathas,
Exhibit 2 is Jamabandi.
my lord.
What is exhibit 2?
2 is a Jamabandi copy, recent one, my lord.
Okay.
And out of that, my lord, only in will, my lord, that is why half is mentioned. Everything is not given to him. In will, my lord, that is exhibit D, my lord. 526, DAG number 526, half, 1 bigha, 4 kathas was willed out. And rest is, out of 3 bighas, 3 kathas, rest is more than, yes, 2 kathas will remain, my lord. And out of remaining 2 kathas, my lord, 4 kathas was the gift deed, my lord. It was given to her. 4 katha 10 lesser, my lord, was given to her, given to the appellant, my lord, in gift deed. So how come Tanuram has come, my lord, in this DAG number? There is no mutation of Tanuram at all. Tanuram has got different DAGs, my lord. They cannot deny Jamabandi copy, my lord. So the entire area, rest of the area, my lord, has not been given to the appellant, my lord. Only 4 kathas, 10 lessers given to her. And out of which, my lord, only on 1 katha she is living. She is staying on 1 katha, and rest 3 kathas, 10 lessers have been occupied by the respondent. That is all, my lord. So Tanuram's thing has been dragged out just like that, my lord.
My lord,
Just to complicate the matter, just to escape from the whole thing.
my lord, may I say, how they are misleading the court, I am just saying, my lord, just I am saying, my lord. My lord, you kindly be with D3, my lord.
Yes.
D3. Starting is there, tag number 405.
It's not
Tag
there,
number-
it's not
Let
there
me,
in
let me, tag
the,
number 405. And my Jamabandi, my lord, exhibit number 9, it is the Jamabandi. In Jamabandi, old tag, new tag, both are given, my lord. In D3, tag number 405. In D9, exhibit D9, my lord. Exhibit D9,
my lord, will
tag
has to
number
be
4,
seen.
405, old, tag number 526, new,
Acha, in will, it is not there,
my lord. My lord, my lord.
Okay, okay. I have
So-
noted.
Similarly, my lord, another my lord, second, tag number 492. Here it is in the family partition, this tag number 492. 492. And this tag number 492 is
So your submission is in all, in
in-
the family settlement deed, all the dogs are
old
mentioned.
tag. At the time,
Okay.
along back. It is
Okay, heard Miss M.D. Chaudhary.
In 95, my lord, this has been, my lord, rectified. And there is now nowhere, my lord, mentioned about the old tag number.
Okay, I'll consider that.
Yeah.
Heard Miss M.D. Chaudhary, London Counsel for the Appellant. Also heard Mr. S. Sharma, Learned Counsel for the Respondent. Hearing concluded, judgment reserved. I'm reserving the judgment.
Right.
Have you gone through?
Yes, my lord, I have gone through, my lord, that is received on, my lord, 17/12/2025, my lord. But my lord, the same way, my lord, other raised statements all are available, then what we are, my lord, looking for, that is, my lord, that is the tuka, my lord, that is the note in the, my lord, case diary. That is not available, other than that, all parts are, my lord, available, where, my lord, the co-accused, my lord, implicated them, and my lord, in this case, my lord, that is the charges already framed on, my lord, 18/9/2025, my lord, under section 126(2), 191(3), 190 and 1031, my lord. And first date of, my lord, that is the evidence was, my lord, 24/9/2025, my lord. That the first then, my lord, PW absent, my lord. And the second date was, my lord, 22/10/2025, my lord.
No, regarding their implication.
Implication is that, my lord, in the, my lord, there is the 48 notice and 47 notice, my lord. When, my lord, they issued, my lord, there's a notice, there is a one, my lord, paragraph that is very clearly states that, my lord, the CCTV footage, my lord, regarding that part is mentioned. Now, my lord, here what we have, we have only, my lord, that is the statements of the witnesses and co-accused that is available as a part of the case diary. But,
Whether-
my lord, that is the toka that is not available with us, my lord. In the meanwhile, my lord, on, my lord, that is dated, my lord, that is the third date of evidence, 18/11/2025. One of the, my lord, that is the present accused petitioner, my lord, in item 3, my lord, Osojit Borua, who filed one, my lord, petition, my lord, praying for, my lord, that is the one USGB clone. That is, I don't know, my lord, what is in the clone available. Might be they are asking for, my lord, that CCTV footage, most
Yes.
probably. Am I right, sir? So that may be, but, my lord, that is to find out that details, what we are looking for, my lord, that is the, my lord, that the entry of the case diary, that is the, along with the notes and all, that is not available. On 17/12 also, my lord, that was sent, my lord. I have gone through, my lord, every part, but I
It
didn't
is not
notice that.
there, therefore it is not available. Had
Might
it
be-
been there, it would have
Might-
been available.
Might be, lordship, but, my lord, without, my lord, that is my lord, that is the entire CD, my lord. Only, my lord, the statements, my lord, to find out this part.
Whether
is not-
entire CD is there or not.
My lord, no, my lord. That is the, my lord, statements are available. The tokas are not available, my lord. There is the case diary entry, my lord. Those parts are not available. 17/12, my lord, they again sent, my lord. That office note is also there. That file is here, my lord. I have again go to that also, my lord. Who is the earlier one, and I have flag marked everything. Because earlier, my lord, rejected that is petitions, and along with these two petitions, only the difference is that in PIP, they are not, my lord. My lord, that is not identified now.
By the team, it Himalayan English. Yeah, you know.
But in the co-accused statement, my lord, those parts are there.
You have flagged it.
So I have flagged mine. All those parts, my lord, I have flagged it, my lord. That is
Okay.
my lord, these are the oldest one. They are-
I'll go through the case diary in
Yes,
pass
yes.
orders. Heard Mr. M. A. Mondol, learned counsel for the petitioner. Also heard Mr. K.
Okay,
Bosho,
Bush.
K. Bosho, learned additional public prosecutor. Let this bail application be fixed for delivery of orders on 27 January. 27 January, I'll pass on. And in other case,
Item number 3.
My lord,
Item
only my
number-
one humble prayer before your lordship, my lord, in this case, my lord, that is the, my lord, other grounds, that is your lordship discretion, my lord, there is prolonged incarceration will not come.
other case, K.R. Bora. 27, same date. Delivery of orders.
Mark of the.
Obliged.
Item 22.
In item 22, my lord, that is the TCR was called for, my lord, that is not received. And my lord, there one Manson memo is there, my lord, so it is fixed today. Otherwise, my lord, the date is fixed on February 3rd, my lord.
Okay. Heard. None has appeared for the petitioner on call. So it appears from order dated 9/1/2026 that this case was directed to be listed on 3rd of February 2026. Therefore, list this case again on 3rd of February 2026.
Item 23.
Worship, in this case, I filed my Wakalatnama today for the sole respondent. This is the filing slip. It has not been tagged with the record. This is the filing slip.
Sole respondent is there. My prayer is, interim prayer is there. The case is fixed before learned trial court tomorrow. So my prayers, interim prayer may be considered.
Item number 20.
23. I am impugning here order dated 15/5/2000.
You have a copy of the,
I have
Yes, sir.
received it. I have not gone through it properly, but what I could see from his readings, if because subject to his, he a petition during the SBPH states four petitions was filed by me. I am the petitioner in this plaintiff in the trial court.
we'll take it up tomorrow.
Yes, your lordship, just accommodation.
Matter maybe disposed of tomorrow itself. Lordship.
Entire matter may be disposed
Yes,
of.
sir.
Okay. So then in admission hearing,
Admission column.
heard Mr. R. Ali, learned counsel for the petitioner. Also heard Mr. D. A. Bishwas, learned counsel who
For the
has,
sole respondent.
for the sole respondent, who submits that he has entered his appearance today and has already filed his Wakalat number and needs some time to go through the petition of the petitioner before making his response. Learned counsel for the petitioner submits that the matter is fixed before the trial court tomorrow and he is praying for interim relief. Stop. It is thereafter submitted at bar that this matter can be disposed of at the stage of admission hearing itself, and both the party agrees that the matter may be taken up tomorrow. Hence, let this matter be listed tomorrow in admission hearing column.
Yes.
Liberty may be given to file an adjournment application before learned trial court
That
tomorrow.
is-
That liberty is always there.
Hello.
Obliged.
14.
May I be pleased, Your Lordship?
Yes, what is this?
My lord, there is a review petition filed by us in the second appeal, my lord. Number क्या है RSA? 97 of 2018, my lord, it's a review petition. RSA is 73 of 2013.
Because RSA was disposed of on 22A.
Yes, my lord,
When-
on 22 to
2018.
2018. And
Yeah.
thereafter we filed a review petition, which was dismissed. And
Thereafter-
then, my lord, an SLP was filed. And the Honorable Supreme Court, my lord, set aside that order and remanded the matter back. The last
Okay.
occasion, my learned friend, Mr. Kamal Agarwal faced this order dated 15/10/2024, passed by the Honorable Supreme Court. I'll place this, but since the matter is remanded, your lordship has to take a fresh hearing.
Yes.
And because some observations are there, but those observations will be without prejudice, I'm sure.
No, what Supreme Court has observed?
Supreme Court has observed, my lord, I'll place that Supreme Court copy of order is there.
It is there.
We are inclined, your lordship got it,
Yes, order dated 15/10.
15/10.
Yes, no, it is there. Yes.
We are inclined to set aside the impugned judgment on the short ground. Namely, in the review, the deceased appellant, Bajrang Lal, has admittedly produced original school admission register dealing with his age, which was declared by his father. In our considered view, the High Court was not correct in dismissing the review petition application file and closing the said document. This is the observation. We are not willing to go into the admissibility of relevance and proof of the said document, as it is for the High Court to consider the same. Perhaps we would only indicate that the High Court can very well call and can very well call for the finding of the trial court on the aforesaid aspect based upon the same. It can be decided in appeal sufficient to say that a scope of review under Code of Civil Procedure is much wider if one considers section 114 read with order 47 rule 1 of the code together. In such view of the matter, we are inclined to set aside the impugned judgment, rejecting the review application with a request to High Court to reconsider it on merit in accordance with law, ordered accordingly. All issues on laws and facts are left open to the parties to raise before the High Court. In the event of review being dismissed, liberty is given to the appellant to challenge the main judge. This is the order. Now, my lord, basically, if your lordship permit me, I'll just narrate the facts
Facts, yes,
very
yes.
briefly. My lord, the original review petitioner was Bajrang Lal Modi. Bajrang Lal Modi. He died, my lord, during the pendency of this review petition. And he is substituted by his wife and son, Srimati Premlata Modi and Suraj Kumar Modi. This was by an order dated 8/4/2019, passed in IAS Civil 618 of 2019.
Yes.
Now, Bajrang Lal Modi Melo was the adopted son of late Meghraj Modi. And
Yes.
The adoption deed was executed on 2nd of September, 2/9/1971. This is Exhibit 2. That I'll take your lordships later on, but first let me just
Yes.
go through the facts, place the facts. Now, the adoption so done in 1971 was accepted by the society. It was never put to challenge. No one even questioned. And after the death of his parents, Bajrang Lal Modi inherited 10 bigha 3 katha 5 lechas from his father and 1 katha 5 lecha from his mother. The land so inherited was mutated in the name of original review petitioner plaintiff. He was the plaintiff. By order dated 23/8/1984, passed in mutation case number 196 of 1983-84.
Yes.
The respondents, my lord, who are in fact biological brother of one of the petitioner here, Bajrang Lal Modi, but he was adopted. So now they can be said half brothers, but they were biological brothers. So they were interfering, my lord, with his position. So he filed a title suit. The suit was numbered as Title Suit 15 of 2008.
No, who are the respondents here?
Respondents, my lord, one is the brother, his brothers only.
Own brother.
All brothers. They were all son of Meghraj, of Sundarlal Modi.
Biological parent.
Biological parent.
Meghraj was the adoptive parent.
Adopted father of this my lord, Bajrang Lal.
Bajrang Lal Modi.
Yes.
Okay. Title suit number 15/2008
2008.
was filed by you.
By my lord, by
Bajrang Lal Modi. Yes.
Now, the respondents, my lord, they filed joint written statement. And in their WS, my lord, they questioned the adoption.
Respondents, there are 4 respondents.
There are 4 respondents.
All 4 are brothers.
Biological brothers, but I'm told one of them was given in adoption to other person. Number 4, but that we are not concerned with that. Yeah, his brother. My lord, for the first time in the joint written statement filed by the respondents, they questioned the adoption deed dated 2/9/1971.
On what count?
On the ground that at the time of adoption, Bajrang Lal Modi was not below 15 years.
Okay.
Not below 15 years, and therefore the adoption deed is void ab initio under section 10(4) of the Hindu Adoption and Maintenance Act 1956. 1956.
Okay.
So this was the only ground
Issue.
taken, and on this ground only the second appeal was allowed. Now, what happened in my lord TS 15 of 2008 is that since they had challenged it in that disputed the land,
What trial court held?
the trial court, my lord, the trial court decreed our suit.
The first
But
appellate court?
And first appeal court is also, my lord, in our favor. Then the second appeal.
Second appellate court, this courts held that Bajrang Lal Modi was not a minor, not below 15 years.
because
Therefore, adoption deed was void ab initio.
void ab-
Okay.
that
That
was
you are seeking review.
yes. Now, my lord, what had happened was, I'll take your lordship to that judgment dated 2/2018 passed by the Honorable High Court. Your Lordship may take.
Page
uh,
number?
My lord, yes. This is, my lord, at page 6. At page 9, my lord, it was a 1.
Judgment dated 22/8/2018.
22 to 2018.
Yes,
Your Lordship will take my review petition.
yes.
Now, your Lordship will kindly come to paragraph, page 21. Page 21. Paragraph 21.
Yes,
The plaintiff respondent tried to establish that on the day of adoption, that is execution of Exhibit 2, he was below 15 years of age. If that be so, he is supposed to adduce evidence supporting the facts of his age prior to 2/9/1971. The deposition of PW3, the principal of the school in which the plaintiff respondent studied, till completion of his school leaving certificate examination in the year 1975, and the manner of appreciation of such deposition by the court below, that he could not produce school admission register due to non-tracing of the same, is not at all inspiring. The evidence that he could not find age certificate of the plaintiff respondent given at the time of admission in the school is vital piece of destructive evidence for the plaintiff respondent, inasmuch as there are 2 different date of birth of the same person on record. Merely holding that there is no evidence to deny Exhibit 1. Exhibit 1 is the high school certificate, my lord, where he was 18 years 2 months as on 1st of March 1975. So his date of birth, if 18 year is subtracted from 1/3/1975, then your Lordship will get 1/1/1957. 1/1/1957, and he will be below 15 years. That was our case. And I'll take your Lordship to the last part of the judgment. And on 5th line from the below at page 23, paragraph 24.
yes,
Paragraph 24.
yes.
5th line, as I am of the view that the court below, that is learned First Appellate Court, had concurred with the findings of the learned trial court, but the same is based on misreading of the evidence and also based on no evidence at all, inasmuch as the age of the plaintiff respondent prior to 1971 has not been established. Accordingly, both courts below erred in accepting the age as per Exhibit 1 certificate on the face of declaration made by the natural father of the plaintiff respondent in the registered deed of adoption, that is Exhibit 2, thereby answering substantial question of law in affirmative. So far, then the court did not go into the other question of law which were framed. Only on this, the second appeal was allowed and my claim was dismissed. Now, I'll take your Lordships through Exhibit 1 first.
P1.
Mark the left side of mark.
Your Lordship will turn to page 5, Exhibit 1. Page 5.
Page number
9. Exhibit 1 is the high school certificate.
Yes. No, Exhibit 1 is an,
Board of Secondary Education.
yes. This Exhibit 1, yes.
If your Lordship will see, written certified that Bajranglal Kumar Modi roll number so and so, age 18 years to 2 months, zero date on the 1st March 1975. Duly passed the high school leaving certificate examination in 1975 of this board and was placed in so and so division. Now, my lord, if your lordship will subtract it, your lordship will find that as on the date of adoption, that is 2/9/1971, his age will be 14 years, 8 months. कल बनाया था ना। One, 3/1975, if we subtract 2 months, 18 years, then it comes to 1/1/1957.
That is the date of birth.
That will be the date, yes. That will be the date of birth. Yeah. Now, my lord, why this was not
What would be his age according to this calculation?
according to this calculation, my lord, he's
2/9/1971, when the adoption date
yes,
was.
it'll be 14 months, 14 years, 8 months, something like that. Nineteen 57 Corona. 14 years, 8 months, madam. Huh. 14 years. Now, my lord, I'll take your lordships through the adoption deed. Exhibit 2. Exhibit 2.
Yes.
Here, if my lord will see, here the age of the plaintiff is mentioned, my lord, at page 7. Page 7. Oh, sorry, second page, internal second. Now, therefore, this deed, my lord, God. Second page.
Yes.
Now, therefore, this deed witnesses that the natural father did, before a family and gathering of friends at Titabo, give his son named Bajrang Lal Modi, aged 17 years, to the adoptive father, who did, before the same gathering, take the said son in adoption as the later adoptive son on the date, place, in and the year first mentioned. So here it is 17 years. Now, what the my lord, the court felt that this is given, this age of 17 years is given as on 2nd September 1971. Whereas the high school, he did it 1975. So that cannot be relied. We should have produced some certificate prior to 1971. This is what, my lord, the learned court said.
Let us read that paragraph
Page
again.
20, paragraph 24. Page 24 at page 24.
As I
am of the view, fourth line, my lord, from the bottom, as I am of the view that the courts below, that is learned first appellate court, had concurred with the findings of the learned trial court. But the same is based on misreading of evidence and also based on no evidence at all, in as much as the age of the plaintiff respondent prior to 1971 has not been established. Prior to 1971 has not been established.
If somebody establish his age at a particular date, it can be calculated on any date, any prior or later date.
absolutely, my lord. And my lord, the reason was, and I was, my lord, the original review petitioner, my lord, was of the view that since the
No,
question-
what court further held that it erred both the court erred in accepting
Yes,
the age as.
it has not been established. Accordingly, both the courts erred in accepting the age as per Exhibit 1 certificate. On the face of the declaration made by the natural father of the plaintiff respondent in the registered deed of adoption, Exhibit 2, thereby answering substantial question of law number 1 in affirmative. And then
So the court was of the view that since two different age is
mentioned one in
mentioned-
high school certificate, the other in the adoption.
adoption deed.
Yes, this is what the court held. Now, what we did, my lord, what we did was, but before that, I just want to point out in one line, the respondents, my lord, did not take to witness box. Except filing the written statement,
Okay.
they did not take the witness box. So the evidence given by us remained unrebutted. As the Supreme Court decision, your lordship knows, if required, I'll place. I have with me. Now, my lord, after this, what we did was, when the written statement was filed, disputing, my lord, the age, then I contacted the principal of Meher Ram Saikia School, my lord, Mr. Bhavani Nath Saikia. And I met him, my lord. He's PW3. And I requested him to please bring the school admission register because the age will be mentioned there.
Okay. Yes.
Now, he came to the court and he, my lord, proves the Exhibit 2, that is high school certificate. He proves it, but he says that I could not trace the school admission register, therefore I cannot bring. Which will show that a request was made by me. So I made an effort to prove my age from the original school registration, admission register.
During trial.
Yes, during the trial.
Okay.
My lord, kindly have compilation 2 I have given.
There is a file.
But
Above. Compilation 2. Second compilation 2.
Yes.
well, at page 20, PW3. Just the relevant portion, I'll take your lordship. The last 3 lines, my lord, at page 20. According to this statement, Bajrang Kumar Modi, father's name was recorded as Meghraj Modi and his age was recorded as 18 years 2 months as on 1/3/1975. At the time of admission of a student in a school, his age is entered into school record of the register. Though I had been asked to bring along with me the admission register pertaining to admission of Bajrang Modi, I could not bring it along because the register could not be traced. Among the records of the school, it is an old register. The board sends matric pass certificate to the school and the school authority issued the same to the student. The statement from which I am adducing evidence bears the seal of the school and the signature of the headmaster so-and-so. I'm familiar with his signature. He has also used his seal. The statement is dated 17/12/1974. The original copy of this statement was sent to the board. So this is the statement of this person, my lord. Now, from here, I want to just make two submissions. I was diligent, that is how I went and made a request.
You made an effort.
Yes, I made it. And the second thing is, this is not in my control. Yet school admission registered is not under my control. It's a government school and it remains the government. And on the day of his deposition, he says it is not traceable. So that is how, after this judgment, the judgment of 22/9/2018 in second appeal, my lord, what I did is I approached Mr. Saikia, principal of
Just a minute.
my lord. Sorry.
Yes. Yes, please.
My lord, I approached again Mr. Saikia, the principal of Mehram School, and again I requested that you kindly trace.
After the judgment in RSC.
After that. Because, my lord, I went to Supreme Court, there I was advised you go and file a review. If you can trace out the register. And otherwise, we will file the SLP against the original order of judgment of the RSA. So I requested Mr. Saikia again. Then I went to the headmistress of the primary school, my lord. It is Titabar Town Government Junior Basic School. I went and met the headmistress.
Yes.
And requested her, my lord, that I was admitted in this school. This is the first school. If you can get me the school admission register of 1962, because I had the information that those days everyone go to school at 5, and the high school certificate shows that I was born in 1957. Therefore, it will be 62. So I went and requested her if you can find out the old admission school admission register, then I will need a copy. She said, okay, she'll get it this thing. Then I was informed that it's available. I obtained a copy of that. It was very old register, so the black and white copy was not clear. So I requested her that at my cost, I will get it I'll get it photographed, colored photograph, and then take it, get the printout, will come, you can tally with it. And then, so accordingly, that was done. And I have annexed that certificate, which the Supreme Court has said with my review petition. That school admission register, enclosure 3 at page 26. Page 26.
Compilation.
No, in my
In the review petition.
Review petition.
Page?
Page 26.
Yes.
Page 26. 9/1/1962. Type 1, I'm first taking your lordship's through. Then the relevant will be the next page. Page 27. One 5/1962, if your lordship will see, date of admission. The just below one or two name from the middle, your lordship will say Bajrang Modi.
This is a typed copy or original?
Type copy
Type
original, I mean original photo state I'll show.
Okay.
So typed copy, your lordship will see Bajrang Modi.
Yes.
And just below, Rajkumar Modi.
Yes.
He is respondent number 1, his brother. And his age on the right-hand side, your lordship will see is mentioned 5, and Rajkumar Modi is mentioned 4.
4.
Now I'll show, my lord, your lordship, the photo state certified copy. Yeah. Underline The registered, well, your lordship will come to page 31, my lord. There is one underline.
Yes.
17th name, my lord, 17th and 18th name. It's not very clear, but then the copy that we were, of course, probably my lord photograph, that is there with us, you can trace. And of course, we will. Third page, my lord, your lordship will see. These are photo state of photo state, huh? Yeah. 62. Which page? Third page. Third page, my lord. Father का नाम है ना यहाँ तो ये
Yes.
Father,
Somehow your name has not been torn. Bajrang Modi.
my lord, yes.
But your brother's name,
Rajkumar. no?
that portion is,
Yes. Bajrang Modi, Rajkumar. The father's name, if your lordship will see. Sundarmal, both.
Sundarmal Modi. Yes.
Age. And age is also there. It's in vernacular 5 and 4. Your lordship can.
Okay.
Now, with this, my lord, we came and filed the review petition, which was dismissed by order dated order dated 5/10/2023. It was dismissed. And then we approached the Supreme Court.
Where is the order dated 5/10?
My lord,
That 5/10 order?
5/10 order is, my lord, we have a copy.
It's a part of the order sheet.
Oh, in this case itself. Okay. Yes, it is there. Yes,
Now,
these facts are narrated here.
facts are there. And
why the court refused to?
then paragraph 12, if your lordship will see, it is clear on the face of record that the petitioner failed to exercise due diligence.
Okay, so you are now saying that due diligence was there.
I said then also in the question arose, I said, otherwise, why should I request the principal to bring the school admission register? I made those submissions there. Now, in fact, after this, I wanted to take your lordships through the Supreme Court.
Yes.
After this. So these are the facts. Now, on this, my lord, our prayer was that your lordship will recall this.
Now, if the age 5 in the year 1962 is taken
That-
to be, then your age will be at the time of execution of deed
Below 15 years.
below 15.
Below 15 years, 14 years, 8 months. That is the requirement of section 10(4).
So this new discovery of new evidence,
Yes, which was not in our control, and despite due diligence, we could not produce it.
now for court to take it into consideration, whether
Order 41 rule 27.
27,
Yes. There is a judgment, my lord, which I'll place before your lordship, of the division bench of this High Court. The only difference would be that in that the review was not disposed of. And during the pendency of the review petition, a petition was filed for recalling certain documents. That decision I'll place. But if your lordship would like, whether your lordship would like to go through the Supreme
Supreme
Court
Court, yes,
judgment, because
yes.
now what I have a feeling in, my lord, that Supreme Court has said that it ought to have been allowed. That means all this it will go back to, my lord, according to my, that is our prayer, that it should go back to the first appellate court, as was done in the Guwahati court by the division bench earlier. And my lord, the first appellate court may be asked to take further evidence. And they will have all the opportunity to
Cross-examination.
whatever they can.
Okay.
So that decision I'll place. But this, after reading all these facts, your lordship now knows. I'll read it again. We are inclined to set aside the impugned judgment on a short ground, namely, in the review, the deceased appellant Bajrang Lal has admittedly produced the original school admission register dealing with his age, which was declared by his father. In our considered view, the High Court was not correct in dismissing the review petition filed and closing the said document. We are not willing to go into the admissibility, relevance, and proof of the said document. It is for the High Court to consider the same. Perhaps we would only indicate that the High Court can very well call the finding of the trial court on the aforesaid aspect, and based on the same, it can decide the appeal. Sufficient to state that the scope of review under Code of Civil Procedure is much wider if one considered Section 114 read with Order 41(7). Now, my lord, according to me, the Supreme Court has observed that your lordship will call for the report from the trial court. That can only be done if the matter is remanded. And for that matter, now if your lordship permit me, I'll place, my lord, Guwahati High Court judgment. This is Braj Bihari Roy and others.
For the report, and the High Court will then, based upon
Yes,
this,
yes.
will decide.
Yes.
They will not appeal. Any review to be appealed.
Yes. My lord,
Yes.
this is this main citation is AIR 1968 Guwahati, page 19, by the division bench, my lord. My lord, my senior's father was there. He sees the judgment, my lord. This is an application for admission of additional evidence in these second appeals under Order 41, Rule 27 of the Code of Civil Procedure, read with the corresponding rule under Order 42 of the Code of Civil Procedure, which makes provision of Order 41 Rule or 41 applicable to second appeal under Order 42 Rule 1 of the Code of Civil Procedure. The facts. The point that arose for determination in these proceedings was whether petitioner was senior to defendant number 2 to 15. The case of the plaintiff in his plaint was that he is entitled to seniority over the defendants by virtue of his service and also by the reason of date of confirmation. The defendant affected contended that they were senior in service to the plaintiff. They were also senior to the plaintiff because they had been confirmed earlier, and consequently the plaintiff is not entitled to a declaration in regard to his service seniority asked for in the plaint, and was also other reliefs. A number of documents would appear to have been placed before the trial court by the plaintiff in support of his stand. The defendant also had produced some documents, but they were not able to place their hand on a document marked XX by the lower appellate court for identification of a letter dated so-and-so, which according to them clinched the question of seniority and established that defendant 2 to 15 were senior to the plaintiff, having been confirmed earlier than the plaintiff. It is also pointed out in the petition that document X was sought to be put in as additional evidence under Order 41 Rule 27 of the Code of Civil Procedure by the government pleader appearing for the Union of India, defendant number 1 in the first appeal, but apparently he did not press his application for decision on the ground that document XX make reference to 2 other documents, which later number so-and-so dated 18th August 1951 and document number so-and-so dated 25th July 1951. And that in absence of these 2 documents, it was not worthwhile pressing for receiving additional evidence of the documents marked XX. The matter ended there. The defendant's appellant now claims that not only this document marked XX important to this case in reaching the decision in the matter, but other 2 documents referred to in the documents have since been traced, and a copy thereof has been produced by the appellant. Accordingly, they pray that these documents may now be received as additional evidence and taken into consideration in deciding the issue in the case, namely the plaintiff is entitled to seniority. The appellants have also filed other documents in support of them, of their stand, claiming that these documents were also not available to them, so could not be produced. The question now falls for consideration in this petition is whether at this stage we should exercise our discretion under 41 Rule 27 of the Code of Civil Procedure in receiving these documents as an additional evidence in the case. Now, my lord, will come to 7, paragraph 7. In the instant case, the main and practically the only point that requires to be considered and decided is whether plaintiff can claim to be more senior to defendant number 2 to 15. If certain documents are available and required to be looked into, which would throw the light on this issue, it would only be proper that these documents should be received in evidence and considered so that the court may more satisfactorily pronounce judgment in deciding the case. That apart, we feel that as this is an important point that trails the decision, a proper judgment on this issue cannot be given unless all these documents having a bearing on the issue are considered by the court deciding the matter. Having thus looked at the document now sought to be put in, we feel that these documents should be taken into evidence and what they for what they are worth and considered on merit and taken alongside the other evidence in the case. We accordingly feel that this is a case where we will be justified in allowing the additional evidence to be received in this case. This does not necessarily mean that we are giving a finding on the relevance or otherwise of all the documents that have been put in. All that we can say is that at least some of these documents are important and have material bearing on the case. These documents should be received. An opportunity must necessarily be given to the petitioner to prove these documents in accordance with law, and similar opportunity in fairness and justice be allowed to the plaintiff to rebut this evidence, if any. Then 9th, my lord, para 9. In the light of our discussion, the question arises is whether it will be proper for this court to receive the evidence in this case, or whether the matter should be sent back to the court below for appropriate steps in being taken in this behalf. We find that not only documentary evidence would have to be received, but there is the possibility of oral evidence being adduced on behalf of the plaintiff to rebut the claim that the documents are genuine. The oral evidence may also have to be adduced in order to prove the document as genuine. Hence, we hold that this matter should go back to the lower appellate court for recording the evidence adduced by both sides in this regard to the additional documents now ordered to be received in evidence. Now, my lord, we'll see the last 12, paragraph 12, the last portion. The result of this foregoing discussion is that the appeal is remanded to the lower appellate court for recording evidence and then deciding the matter in the light of direction given above. But this is slightly modified in the judgment of the Supreme Court. This, that they will decide. Supreme Court, what Supreme Court
No,
says,
in the appellate court, decision was in your favor.
yes,
So question of
again deciding doesn't
again
arise,
deciding does not arise.
because here they have remanded. Now here what the Supreme Court says, my lord, is this. I'll just take it.
Supreme Court in this case, our case.
In this case,
Yes.
1510, order dated 1510. 1510. Second paragraph, my lord.
Yes.
Second paragraph. We are not willing to go into the admissibility, relevance, and proof of the said document, as it is for the High Court to consider the same. Perhaps we would only indicate the High Court can very well call for the finding of the learned trial court on the aforesaid aspect based upon the same. It can decide the appeal, sufficient to say the scope of review under so and so is higher. So what they say, my lord, if it can go back to the trial court to take this evidence on record and to record whatever evidence is there, and then it can be repeated here, and your lordship will decide the appeal.
That is one option available to this court, according to Supreme Court.
Yes. Yes.
Okay.
Because your lordship will not take up the evidence. So it should go to the, either Supreme Court has said trial court, because trial court has to now,
But it has remanded back the review application to this court to decide it,
not decided. So your lordship will decide it,
consider it on merit.
yes, after. Because the first para says High Court was not correct in dismissing the review petition. Therefore, according to me, my lord, your lordship may dismiss or this thing after getting the findings. Till then, Yes, 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 yes.
You will decide the review again.
Yes, yes.
based on the press evidence.
Okay. No, the apex court has not directed what is to be done. It has only given an indication that this can be done. This can be done.
That's what I'm
And
saying.
your submission is that this should be done.
No, my submission is that because what my submission would be, my lord, if your lordship allows this review petition, allows an additional evidence to be taken, then the question is where it will be taken,
Okay, okay.
where it will be taken. Now, it can either go to the first.
Then it
appeal
has
court,
to be remanded
remand.
only for the purpose of
That only.
adducing of evidence.
Producing evidence, after that, your lordship will, they will submit it here, and your lordship will decide on the basis of that.
Yes.
This is what the Supreme Court has said. And my lord, purpose of referring Brajabihari Roy is that there is an option. Because the High Court will not take evidence. Although I'm not saying it doesn't have power, but then, no.
Whether along with your review application, any application under Order 41 Rule 27 is necessary.
It's there. Because it will be in the review only. There won't be a separate petition under Order 41 Rule 27.
In the review
Because
piece,
their application, my lord, in that Brajabihari, that application was there because the second appeal was not decided. It
no,
was
in
still-
review petition, what is your prayer?
in review petition, madam, the prayer is to review the,
But before that, this additional document has to be taken into consideration.
my lord, I have mentioned, if the lordship will kindly see, paragraph 4. Paragraph 4. Paragraph 4 and 5, my lord. Oh, at page 5 of my review petition, my lord. Lordship got it, my lord?
Yes, para 4.
For that, the school is admission register of Titawar Town Government Junior Basic School, Jorhat, in the year 1962, as well as transfer.
No. My query is different. My query is you preferred the review application because a new document is
Yes.
which
yes,
was not there with you
yeah,
earlier.
Yes. Well, that's how I
Now,
wanted
to bring
place-
that on record, whether in exercise of whether a simple review application would be sufficient to,
Well, we have.
because that document which you are relying is not brought in to the case as evidence.
No, it has not been brought as evidence, but only statement is there. If your lordship will I was placing 4 and 5. 5, your lordship will kindly see.
No, my query is whether under 114 order.
8, if your lordship meet your lordship's query, paragraph 8.
Yes, the second appellate court. Yes, there is a pair.
There it will.
But this, whether this power is there in order 47 rule 1, read with 114.
Order, this order 42, if your lordship, because that aspect has been gone into by the judgment that I have placed.
Apex court.
No, the division bench of.
Oh,
with-
yes.
Yes, that.
But there was an application under order
Yes,
41 rule
that was
27.
an application, because the.
That is my query. Here is there any such application is
No,
pending?
because the case was disposed of.
Yes. Now whether such application would be required or not.
Well, in my humble submission, if we have filed a review petition, we have made a statement in paragraph 3, 4, 5, and 8, altogether it has to be filled in. Then it's very clear that subsequent discovery, which comes under, which will fall squarely under order 47 rule 1. Lord, you can kindly see.
Yes.
47 rule 1.
Whether order 41 rule 27 is applicable in
Yes.
review proceeding also.
Yes. It will apply in my lord order 41, but
Yes.
my lord, in the second appeal, your lordship has seen that there is a provision where order 47 rule 1 or 41 rule 21 will apply, my lord. So therefore, my humble submission would be, my lord, there will be no bar in your lordship. Because if your lordship remember, I placed paragraph 4 of this Braja Bihari. Because there the question now falls.
No, but Braja Bihari judgment was
Not in review.
on an application under order 41 rule 27.
Yes.
So that is only my query. Now,
My lord, if your lordship so wish, this is stage.
now what is to be done?
So No, we have no, this thing, we can file an application.
That is my query, whether an application would be required or not. Under
My
order.
lord, at the first thing, my lord, my submission would be that since we have made a mention in the review petition of taking additional evidence, which we have subsequently discovered, it can be, but if your lordship so required, we can file an application for calling them.
Okay.
Or invoking order 41 to 20.
And suppose such an application is not made, whether this court can invoke its powers under order 41 rule 27. Anyway,
Well, the answer is in the Supreme Court order only.
no,
Not in that detail, but there is an indication, my lord. And then perhaps we would only indicate, this is an indication that the High Court can very well call for the finding of the trial court on the aforesaid aspect.
yes, this is one option.
Yes, the Supreme Court has given, and this is an indication only.
Therefore, I'm putting query
Yes.
that whether order 41 rule 27 application would be required or not,
I'll file, my lord, let's.
if required.
We'll file an application.
Okay. Yes, Mr. Anything else? Mr. Sahel?
My lord, first thing on the point of due diligence, my learned friend has relied on the evidence of P23. My lord, P23 is the master of the higher school, my lord, where original entry is not made, my lord. He has not gone to the school now where he has gone to bring this record. He knows that was the school donated by them, their predecessors. I shall place to record. My lord, my lord. If your lordship will take the, my lord, volume 4.
No, your submission should be in light of the apex court's observation.
I'm
No,
saying-
apex court
yes.
has observed that High Court
No,
has
no,
erred in rejecting the.
yes, that is correct, my lord, that I'm coming, that is another one aspect. But here you said that we are not willing to go into admissibility, 11th proof of document. Next page. Last one. In view of the matter, we trying to set aside the impugned judgment rejecting the review so and so, to reconsider it on merits in accordance to law. So, my lord, your lordship has to consider both, my lord. Whether, my lord, that they have
Due diligence was
due
there or
diligence
not.
was there or not. Because he has only approached the headmaster of the higher secondary school, high school. High school. So high school, my lord, original entry is not made. And moreover, here, the important thing is this, the natural father has declared his age as 17 years on the date on which the adoption deed was signed. Because his basis for adoption is adoption deed, not other document. Where consent of natural mother is not there also, that is another aspect of matter, which is also compulsory. So adoption deed, whether they want to set aside the adoption deed. My lord, I'm just posing, my lord. Whether it is said that his father has declared as falsely. Because his father has declared the age as 17 years in the adoption deed, my lord. And on the basis of the adoption deed, he was adopted.
No, but the regular second appeal was dismissed only on the ground that the appellant failed to produce any
Correct, my lord. But-
document showing
but
his
thing is
age
this, my
prior
lord.
to 71.
Yes, yes. But thing is this, The adoption deed is very important here because the age in the adoption deed was declared by the national father. Mother was not there. Mother's consent is also not there, although it is compulsory. That is also important, but that is to be considered by your also, mother. Because in school also, the father, they've said that father declared age. Father also declared his age in the adoption deed also. And I shall place other things also from the register. Because due diligence is not there at all, my lord. Because they knew it that they were admitted in the primary school initially, where his age is recorded. They have not approached the primary school, my lord.
No, they approached the
High school.
high school.
High school, but original it is not there. Because on the basis of certificate from the primary school, they are admitted in the high school. High school, and so, my lord, the certificate, the transfer certificate comes from the lower school first. Primary evidence is only in the primary school, my lord.
Normally, the age is ascertained on the basis of high school certificate.
High
In
school
this
certi-
case, what my understanding is, in this case, this court dismissed the RSA because of the entry in the adoption deed regarding his age to be as 17 years.
Until the adoption deed is-
Two contradictory ages.
Yes, but who has made the adoption deed? Who has declared the age in the adoption deed? It is the father, natural father. But that is very important, my lord.
Okay.
And mother's consent is also not there. That's understood.
Yes.
Well, your lordships may just see, we have filed an objection when they filed a review petition on the basis of the documents. Your lordships may see that objection, compilation 4 at page 33. I can place the queue.
Objection by 123.
Yes.
Yes.
My lord,
Page number?
page number 33. At page 34, pair 2.
Where? In the
Compulsion 4, compulsion 4.
Yes.
The documents annexed as annexed 2 and 3 are not genuine documents. These are several discrepancies into documents, and the same cannot be taken into consideration by the school court. From annexure 3, it appears that the age of the student has been mentioned arbitrarily without any basis, and the counsel for the respondent will place that the student is at the time of hearing. I shall place that also. Then admission list at the age column are left blanks, and in case of the prisoner, it is so it can be assumed that the age of the prisoner was also left earlier, but later it was filled up as 5 years. This is easily possible because late Meghraj Modi donated the school building in the year 1948, and later Bajranglal Modi assumed the son of Meghraj Modi has been taken into school. I have given the photograph
No,
also,
no.
my lord, next X.
No, the merit and demerit of that document
Yes, I am coming.
cannot be taken into question now unless it is first brought in evidence. So you can object to their prayer for bringing it in evidence. We cannot go into the merits of the said document now, you will get that option if the court allows their prayer. You may cross it.
That is correct, but that your lordship will see, there is no prayer, my lord, that only this is the ground, my lord. Para 8, my lord, my land has shown
Yes.
in the review petition, that is a ground only. For that, my lord. For that second appellate court, is receive the additional form of document which is public nature. Can receive. For that. This is not a prayer.
Let them file an application,
My lord,
application under order 41 rule 27.
I should file, my lord.
No,
They have not.
they,
That they have not. Complaint. My lord. My lord, actually, in the plaint also, my lord, nothing is there, my lord. If your lordship go.
no, they have submitted, now they are intending to file.
My lord,
You have objection.
even after amendment also, my lord, of plaint, they have not done it. In 2008, they have made an amendment also. After we signed it up. After signing of the WS. Which is in compulsion 1.
Okay. No, what is your submission regarding the observation of the apex court?
Yes,
That
I'm
what this court can do
My
now?
lord, yes. My lord, court has merely said that we are not going into the admissibility relevance. Relevance is very important for proof of the said document. Whether it is relevant or not. Because I shall place a judgment of the same judge, my lord, who passed the judgment of the Supreme Court, my lord. That will make it clear, my lord.
Regarding,
Review.
yes,
And this honorable court was allowed to all issues of law and fact are left open to the parties to raise before the High Court. All issues. Now that judgment I shall take. My lord, 24, 6 SCC 461. Now, there are many judgments I shall place in the, my lord. But this is the judgment I place a few paragraphs. I shall place paragraph 24 to 29, my lord. This is judgment delivered by Justice M.M. Kundas, who passed the order.
yes, what it says.
My lord, paragraph 24, my lord. Page 477. The lordship got it, my lord.
There are 24.
20.
Yes,
Section 114, reduced order 47, rule 1, or CPC 908 is virtually similar to section 623 of 1877, except that on order 41, which was aided by your amendment in the year 1926. Section 114 CPC speaks of the circumstances, instances, and situations under which a review can be filed. The words as things fit cannot be interpreted to mean anything beyond what is conferred under order 47, rule 1. In other words, section 114 is to be read along with order 47, rule 1. While they are to be read together, section 147 is procedural, whereas order 47 is substantive. substantially. Now, the word due diligence, though one of the fact places onus heavily on one of the who seeks a review, it has been seen from the point of view of a reasonable and prudent man. Though an element of flexibility is given to any evidence or matter on the discovery, it has to be one which was not available to the court earlier. Very important matter. They have not approached the primary issue. It could not have been produced despite due diligence, meaning thereby that it should not have been made available and therefore in existence at least at the time of passing the decree. Mistake or error upon the first record would debar the court from acting as an appellate court in disguise by indulging in a decision, however erroneous, can never be a factor for review, but can only be corrected in appeal. Such a mistake or error should be self-evident on the face of the record. The error should give enough to be identified on a mere cursory look, on an omission so glaring that it requires interference in the form of a review. Being a creature of a statute, there is absolutely no room for the press hearing. The court got only role to involve itself in a process of adjudication for a second time. Instead, it has to merely examine the existence of an apparent mistake or error. Even if two views are possible, the court shall not indulge by going from it. The material produced at this stage should be such pristine quantity which, if taken into consideration, would have the logical effect of reversing the judgment under 47 Rule 1. Indicates that power of review can be exercised by courts in three different situations, but these occasions ought to be read in analogous manner. In other words, they should be read in a manner to mean that a restrictive power has been conferred upon the court. As stated, the words for any other sufficient reason ought to be read in conjunction with the two earlier reiterating scope. Being a judicial decision, it has to be exercised with circumvention, and on rare occasion, its power to be exercised by an exception, such as because now next, a subsequent event per se cannot form the basis of a review. Clause C of Order 47 Rule 1 CPC clearly specifies that an important matter or evidence produced must have been available at a time when the decree was passed. This is a matter of rule. On a very rare occasion, an exception can be carved out. Such an exception can only be exercised when the said matter or evidence is of unimpeachable quality. Well, this is also important. That is why I shall place. It is not only a new matter or evidence that should be taken into consideration, but it should also be an important one. While exercising the said power, courts should first check the evidence value of the such discovery. My lord, this I am placing, my lord. Including the circumstance under which it emanated, particularly when it inherently lacks jurisdiction or evidence cannot be made admissible in law. Therefore, it is not relevant. In such circumstances, there is no question of proceeding further in deciding the review application. Next, my lord, para 30 to 36. 31, my lord. Earlier judgment has been considered. This is only on the basis of review, my lord. So my humble submission, my lord, this judgment has clearly said that prima facie or also you can see, my lord, whether these documents are genuine or not, my lord. That is why I want to place my objection, my lord, not here. Then, my lord, your losses may come to my objection. At page 35 of the appellate report. There are three. On physical verification of register, it was found that the register was tampered and all the pages are covered. Quite transparent sheet in the name of privatization. The date on which register was binded at the same date, at the date of application by Bajranglal Modi. And it was mentioned that after death of Bajranglal Modi, the death certificate was issued by Sri Gangaram Hospital, Delhi. And that certificate, the age of the Bajranglal Modi was mentioned as 64 years on 6/1/2019. Thus, approximately, his date of birth was 54 to 55. Further, as per admission register, the difference in age and Rajkumar Modi is only 1 year. Whereas actually the Bajranglal Modi, Bajrang Modi is 4 years older than Rajkumar Modi. My lord, this is very important, my lord. Rajkumar Modi is 4 years younger than Bajrang Modi. How you lost, my lord? Further, Sushila Devi and Dao Kumar are not twins, and it is known that the answering responded they are neighbors, and as such, the same is not correct. So far, age of Prithvi and Ranjan Rai and Asa Ranjan Rai, both sons of Asaram Rai, were shown as 4 years, 3 months, and 3 years, 6 months. Well, how you will believe this, my lord? I should go to observe, my lord. Which is impossible. Similarly, age between both the children of Dwarika Prasad is 6 months. For this reason, the admission register is cannot be right out. Only 6 months, the difference of age. I shall place from the, and it is donated by their father, my lord, that you also find at page 37. This school was donated by the father of the Modi. Then if your lordship come to type copy, my lord, at page 27 of the same book. Volume 4.
Right copy of,
My lord, admission register.
yes.
My lord, top, my lord, your lordship will see, find Prithvi Ranjan Rai and Ashish Ranjan Rai. Both are, my lord, sons of Ashish Ranjan Rai. Your lordship, page 27. Your lordship may just.
Page 27 of compilation 5.
Oh, yes, 4, volume 4. Volume 4.
Yes. Yes.
Prithvi Ranjan Rai,
Which serial number?
serial number, my lord, second.
Yes. Who is Prithvi Ranjan Rai?
Prithvi, one of the my lord student, Prithvi Ranjan Rai, he is the son of Ashish Ranjan Rai. Next one is Ashish Ranjan Rai, son of Ashish Ranjan Rai. Both are sons of. Now, if you also see the age, my lord, on the right hand column. First one, Prithvi Ranjan is 4 years, 3 months. Ashish Ranjan is 3 years, 6 months. Absolutely, my lord, impossible. Then, middle portion, my lord, Malakar, Begum, no age has been, many age are not there, my lord. Then,
So you are submitting this is not genuine.
not any document at all, my lord. Now, your lordship may come to page 28 also. Again. If
Yes.
Bajrang Modi was shown as 5, Rajkumar Modi 4. Well, Rajkumar Modi is 3 years younger than Bajrang Modi. Then Sushila Devi and Chand Kumar. These are both Gauri Shankar. They shown, my lord, 5 years, 4 years. Absolutely, my lord. This is not a document, my lord. And the original copy, as you also seen, my lord, that what is there, my lord. Here is the primary document is there, my lord, the adoption deed, where the father has declared the age. Huh? So can it be changed, my lord, as extra deed cannot be changed, my lord, so in this way. They have not approached the, also, my lord, to change the adoption deed. Adoption deed is very much there, my lord. And age was declared not, no more be done by a father. And mother's consent is also not there, my lord, here. They tell mother. This is a mark.
Anything.
Now, there are number of judgments, my lord. I have prepared a compilation also, my lord. I shall place that one. I'm just. Because on due diligence also, my lord, I am placing several judgments. Although I have placed the judgment of Justice Sundaresh, my lord. But many other judgments I am placing. I am giving a copy of my other side also. And on due diligence, the judgments are, my lord. These are judgments. Then, my lord, I shall place the judgments on review also, my lord. Hmm? but उसमें लिखा हुआ है सब नहीं उसमें argument सब लिखा हुआ है और ये हमारा review judgment one judgment of our High Court is also there. Justice Surana. I quoted, my lord, in my my lord, I have also relied on 3 judgments on review also, my lord. These same are also there. One is 2017 4 SCC 692.
On what point?
On review point, my lord. Both points are there. Then limited scope. Then 18 4 SCC 587. And then our High Court judgment is 18 2 SCC 403, my lord.
You mark the paragraph number also.
Yes, I have given, my lord, in my written. Yes, I shall give you a few, my lord. My lord, my lord, separately I am giving it. I'm giving one for those. Need an argument, my lord?
On the same point, you have given so many judgments. Is bombarding of.
But some relevancy is there, my lord.
Okay.
I
Any reply?
I had 4 lines. So I just wanted to tell my lord, I had a senior colleague. His name was W.S. Hisaki, became judge and retired as Chief Justice. We were practicing together in Nagaland, Dimapur. So he will come with this much book And he'll say, Your Honor, this is on this, and I have given this. I bombarded, I was.
I have placed a little judgment.
Well, just 4 lines.
Yes.
Just 4 lines to his, well, first of all, about the mother. It is mentioned in the gift, in the adoption deed only that she expired. And that is written at page 24, paragraph,
Expired prior to
Yes, yes.
making of
yes, yes.
adoption
yes.
deed.
Paragraph 24 at page 23.
Adoptive mother.
Yeah, adoptive mother. Oh, you saying my mother.
Natural mother.
Anyway, that has not been gone in. Your lordship will kindly come to 24, my lord. 24. So far, my lord, 3rd line from top. So far, the substantial question of law number 2 is concerned. On perusal of exhibit 2, deed of adoption, it is apparent that wife of the adopted father plaintiff respondent died prior to the adoption. As such, the same has no substantial bearing on the decision. So with that, it goes. Now, then, my lord, I'll take your lordships to the order which was challenged before the Supreme Court, dated 5/10.
Where I will find that order?
My lord, in the order sheet, my lord.
Oh,
Five,
yes, yes.
510.
It is there.
Your lordship will see paragraph 12. Paragraph 12. 5/10/2023.
Yes, para 12.
Para 12. This was a finding which has been undone by the Supreme Court, my lord.
Mainly on the exercise of due diligence.
Yes, this has gone by the order dated 15/10. It cannot be looked up again. Then, my lord, so far as whether the admission register of MHR at Mihiram Saikia High School would contain the date of birth or would contain what, that is concerned, there is a finding, my lord, in paragraph 21 of the judgment, my lord, dated 22, page 21, my lord, of this RSA judgment, my lord. I read it all now, I'll read it little slowly. Page 21, paragraph 21.
Yes,
The 3rd line from the top, my lord.
yes.
The deposition of PW3, the principal of the school in which the plaintiff respondent studied till completion of high school leaving certificate examination in 1975, and the manner of appreciation of such deposition by the court below. He could not produce the school admission registered due to non-tracing out of the same is not at all inspiring. The evidence that he could not find the age certificate of the plaintiff respondent given at the time of admission in the school is a vital piece of destructive evidence of the plaintiff respondent. So therefore, my lord, that school admission register, if it was placed, it would have contained many, because that school doesn't start with class 9. It starts with class 5. That Mihiram Saikia. It starts with 5. So it cannot be imagined that what will be there and what will not be there. Then, my lord, the other is the decision that has been placed by my learned friend, my lord. My learned friend on due diligence of the Supreme Court, stated to be by the same judge. I'll only say, my lord, that the order of the Supreme Court, the judgment cannot be assailed on the ground that the same judge has given judgment differently in another case. These are inter-party judgments. He appeared. We appeared. Therefore, this inter-party judgment cannot be, well, ignored or cannot be said that it is not valid because there was an earlier judgment. In an inter-party judgment, it is binding on him as well as me. This one.
Heard.
My lord, one paragraph, I will select from the judgment, my lord, of the second appeal. Page 20 of page 44, my lord, volume 3, my lord.
Which judgment?
Judgment. Yes, my lord, second appeal judgment. Page, paragraph 20.
Para 20. Yes.
The defendant appellant the written statement disputed the validity of the adoption because the age mentioned in Exhibit 2 and also for absence of the consent of the natural mother. Well, it's there. Plaintiff respondent produced so and so deed of adoption. However, there is no explanation that pleadings about the incorrect recording of the age in Exhibit 2, nor about the variation of the same with one mentioned in the certificate one. The said deed Exhibit 2 relied by the plaintiff respondent in order to prove the adoption was a valid one and to get benefit of the presumption under section 16 of the Act of 1956. The said deed of adoption Exhibit 2 proves the fact of giving and taking of the plaintiff respondent by the natural father to the adoptive father. Exhibit 2 was registered on so and so. Exhibit 1 certificate had in existence on 23/7/95 as apparent from the mentioned so and so Exhibit 1. The date of adoption so and so Exhibit 2 as mentioned by plaintiff respondent was found 17 years. The fact of adoption does not comply with the provision of stipulated under section 10 of the Act. The fact of adoption claimed by the plaintiff respondent on the strength of Exhibit 2 is invalid. There is no mention in respect to the Homa, which plaintiff respondent tried to bring by of evidence of Pillar 2, Sankala Sharma, though there is no such pleading with regard to a said fact of religious ceremony, and the said piece of evidence of PW 2 cannot be considered. So, my lord, they accept adoption deed, nothing was there. Your lordship may just see, my lord, the section 7 of the Hindu Adoption and Maintenance Act.
What it provides.
Yes. Any male Hindu, section 7 of the Hindu Adoption and Maintenance Act, page 79, I think. Page 79. No.
Section 7. Yes.
Any male Hindu who is sound mind, who is not a minor, has the capacity to take a son or daughter in adoption, provided he has a wife, he shall not adopt except with the consent of the wife, unless wife is completely and finally renounce the wife or has ceased to be Hindu or has been declared by the court so and so. This is my concern.
On this, you have any reply regarding the consent of natural mother, not adoptive mother? What you have shown.
It doesn't require whatever he has read, your lordship will see. Any male Hindu who is sound mind and is not a minor has the capacity to take a son or a daughter in adoption. So it is for the adoptee mother and father. And moreover, this has not been dealt with in the judgment under review. This hasn't been dealt with. This Exhibit 2 is gone. The question number 2 of the review.
Substantial question.
My lord?
Substantial question number 2.
My lord, 2. This question has not been gone into. The issues are framed in at page 12 of the review petition.
Section 9, my lord. And
that has not been gone into.
What section 9 point? No, how section 8 is not applicable? Section 7,
Section, say he placed section 7,
section 7.
because section 7, according to me, it's not applicable
Why?
because it is meant for the adoptive father and his wife, not for the one who is giving. Because so what your lordship will mark,
Yes, please read.
please. Any male
Hindu
Hindu
adoption.
who is,
Yes, please read. Any
male Hindu who is of sound mind and is not a minor has the capacity to take,
or to take into
take
adoption.
the son or daughter in adoption.
Okay.
So it's not gift.
And
Section 9. my lord,
Nine,
I'm sorry.
not
I'm sorry. No. No persons except the father and mother or the guardian, the
Disjuncted.
child shall have the capacity.
or is there?
Yes,
Subject to the
disjunctive.
provisions of subsection 4, the father or the mother, if alive, shall have equal right to give a son or daughter in adoption, provided that such right shall not be exercised either of them, save with the consent of the other, unless completely or finally renounced or what. This proviso. This is.
This was dealt with by the impugned judgment.
My lord? That was mentioned. There are 20 present.
Any reply?
Is required for this.
Heard Mr. D.K. Mishra, learned senior counsel, assisted by Mr. B. Prasad. Also, for B. Prasad for the review petitioner. Also heard Mr. G. N. Sahewala, learned counsel, learned senior counsel, assisted by Mr. A. Sahewala, learned counsel for the respondent. Hearing concluded, judgment reserved.
The original certified copy I had given, if I can take it back, or your lordship.
To return accordingly.
Lordship also can retain, this is the whole,
No, I have already gone through it.
then we take it back.
Yes. Any mentioning?
Please, Your Lordship, I'd like to mention item number 22 for withdrawal of the matter. We have also received the NOC for withdrawal of the state matter.
We withdraw as counsel.
Yes, Your Lordship,
You want to,
from the case. The petitioner would like to withdraw the case.
no, item number 22 is fixed on, it is fixed on,
Your Lordship,
already
there-
orders have been passed.
There's a little urgency regarding the withdrawal.
What urgency? What urgency?
It's been 304 days but he would like to change the council. The petitioner
He may change the
from
counsel.
us. Like he would like to change the council, Your Lordship.
There is no bar. Okay. What is your name?
Nevar.
Who is the engaged counsel?
G Datta.
He has to
G-
make submission.
Even my
Your
name is
name is
there
also there.
in the Vakalatnama, Your Lordship.
Heard Miss A. Nevar. Item number 22. Later on. Heard Miss A. Nevar, learned counsel for the petitioner, who submits that the petitioner intends to withdraw the brief from them and engage a new counsel. The present set of counsel for the petitioner does not have any objection regarding the same. And they have also given NOC required for change of counsel by the petitioner. The prayer is allowed. The registry shall not reflect the name of Mr. G. R. Datta and Miss, what is it?
Nevar.
A. Nevar has engaged counsel for the petitioner in the cause list henceforth, list accordingly.
Obliged.
Make it a systematic.